Good evening. Hello, everyone. Carl Steinbeck here. Want to talk about day 21, Commonwealth of Massachusetts versus Karen Reed. And it was quite a day, a lot of stops and starts, but start out mostly stops, I should say, as there was like almost a 90-minute delay this morning just because there was a lot of stuff on sidebar that should have been an open court. So when they're discussing evidentiary issues, what we have is that should be an open court. The jury's not there. That's always an open court. You don't have sidebars. So the whole reason they're having sidebars is so us, the viewing public, can't see what's going on and what kind of stunts they're pulling against the defense. So it's very secretive kind of tribunal here that the public's being denied to see what's really going on when the jury's not there. If the jury's not there, then the public should be there. The cameras should be there. But there's all these secret sidebars where we won't find out what's going on until after the trial. Maybe it's a freedom of information, and this thing is long and forgotten about. But it's very, very much what I see as an effort to conceal all the shady stuff going on. And so it is something I would think media would do something to file a suit to request media access to the sidebars and to block them as well. So anyway, it's a day that the Aperture expert testified, Judson Welcher, and this guy was like, wow, he's really given Trooper Paul a run for his money, but in a lot of different ways. So I'm going to go through that. Normally I don't do the direct examination. We didn't get any through even his direct examination today. So after about almost an hour and a half delay, then there was a opportunity for defense to do a voir dire on him. And this all has to do with the fact that he changed. Remember, we had Burgess changing some of the dates on his report. So obviously there's going to be some kind of collusion going on with Burgess also letting his higher up know, this Welcher guy, know that he's changing some time windows as well. So his report's going to change also. So let's go ahead and jump into this. Okay, here we go. This is the voir dire.
You solemnly swear the evidence of the court in case now and here should be truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir. You're welcome. Good morning, Your
Good
Honor.
morning, sir. So we're going to have a short voir dire.
Yes, ma'am.
Okay, so Mr. Lessie?
Thank you, Your Honor. Thank you.
Morning, Dr. Welcher.
Good morning.
If you look at any documents in answering my question, I appreciate you letting me know that, okay?
Okay,
Do you have any documents open in front of you at this moment?
I do. I have a binder.
Your Honor, I would ask until the question
Can
comes
you
up.
do without it, sir?
Okay. Right there. How rude is this judge? She's intentionally doing this to cut him off, even though the jury isn't there. It's just another dig at defense. So let's back that up. I've never seen a judge just routinely cut off defense attorneys. She's never once done that to the prosecution, either Brennan or Lally. Never once.
Morning, Dr. Welcher.
Good morning.
If you look at any documents in answering my question, I appreciate you letting me know that, okay?
Okay,
Do you have any documents open in front of you at this moment?
I do. I have a binder.
Your Honor, I would ask until the question
Can
comes
you
up.
do without it, sir, for a few minutes?
Depending on.
Look at that. You're just a schmuck in there, Leslie. You're not deserving of any dignity and respect of this person in this black robe. So
Question? Sure.
Okay, so just let us know if you need to look at it. Don't look at it without
I mean,
permission, please. All right, go ahead, Mr.
Thank you, Your
Lessie.
Honor. Dr. Welcher, you have changed your PowerPoint presentation in the last few days in this case, correct?
I deleted a slide and removed a couple words.
Right, but you've changed your PowerPoint presentation, correct?
Correct. I deleted a slide and deleted a couple words.
Who have you spoken to at the Commonwealth in the last 2 weeks? Anybody associated with the Commonwealth? Who have you spoken to?
In the last 2 weeks, Mr. Brannon, Mr. Lally, Lieutenant Tully.
Anyone else?
I think Mary Ellen Gray,
Anyone else?
the tech person Cindy this morning.
And with regard to those conversations, what prompted those conversations? Who initiated them?
I was originally told I was going to have to be out here last Monday. So there was a whole flurry of conversations around that. I was initially told I may have to give all my rebuttal testimony on a whole huge data set I'd received.
I'm sorry to interrupt you, sir. My question was simply because we have a limited amount of time. Who initiated the conversations?
Oh, there were multiple.
Yeah, I'm sure she gave him such a short fuse that he's got to be rushed through this. And you've been holding up the court for almost 90 minutes. And now you have this limited window of voir dire, all because the prosecutor's playing ambush against the defense. And the judge just randomly and routinely ignores all this stuff that Brennan's pulling and lets him get away with it. So
Multiple conversations.
How many?
I have no idea.
More than 10?
I'm sorry?
More than 10?
Probably not.
All right. What did you discuss with, do you understand it's no longer Detective Lieutenant Tully? It's, as I understand, it's Lieutenant Tully. Did you have you said you had conversations with him, correct?
Correct.
When was the first conversation? How many? And what are the nature of those conversations?
Are you limiting it to the last 10 days or in total in my life?
Within the last 2 weeks.
Last 2 weeks. I believe it was when I got here on Saturday night, I informed them I'd landed. And then Sunday morning, he gave me a ride over to the district attorney's office.
And what did you discuss from when you, did you have any discussions with Lieutenant Tully before Saturday, within the last 2 weeks?
Not to my knowledge.
What did you discuss with Lieutenant Tully? Topics.
Give me a time frame.
I keep saying the last 2 weeks. That's the time frame I'm looking
all
at.
the conversations I had with him.
Yes,
Can you have somebody pick me up at the hotel?
I'm talking substantive.
you can't even get an Uber. That's how this guy is. He's an accident reconstructionist, and he knows how to explain everything about all the electronic workings of vehicles. And he's asking to be picked up because he can't take an Uber.
Sir, about your outline, your PowerPoint presentation. Topics of what discussions about the topics in your PowerPoint presentation?
I had no discussions with him about the topics of my PowerPoint presentation.
Who did you have discussions with from the Commonwealth about the topics in your PowerPoint presentation?
Mr. Brannon and Mr. Lally.
Describe those conversations and how many you had, including the first one that you had.
Well, I originally submitted my presentation with my original report way back, I believe in January.
Right. I'm asking for conversations within the last 2 weeks.
Okay, question wasn't clear. Then on Sunday, we just went through top to bottom through my presentation. Mr. Brandon wanted to make sure he understood everything in it. And then I met with Mr. Brandon again on Sunday. We ran through it briefly again.
Yeah, but did you also get coached on how to come across when defense is questioning you? That's what he didn't mention. I'm sure that what kind of questions the defense would ask would have been gone over with this witness as well, but he conveniently leaves that out.
And then that was largely it.
Who suggested the changes to your presentation?
Mr. Brandon.
Mr.
Right
Brennan
there.
suggested the changes that you make.
He indicated some of the things, for example, the slide I deleted referenced.
Yeah, look at the way Brennan treated ARCCA witnesses like they were just some hired shady guys that would testify to anything they're paid to say.
Testimony that I was not allowed to include on a slide.
Were there any discussions with anybody from the prosecution team about the changes with regard to the what I will call the Dighton route, the Dighton distance, and the total mileage. Do you know which slide I'm referring to, sir?
I do, yeah.
Who initiated the discussion on the changes to that slide?
So that slide was changed, I don't know, probably 8 or 10 days ago.
Oh, it was changed 8 or 10 days ago.
Correct.
Were there any changes made from 8 or 10 days ago to what's now in your presentation?
Not beyond what we talked
Oh,
about.
okay. So 10 days ago, those changes were made.
8 to 10
8 to 10.
days ago. I could actually probably figure out exactly when, if you like.
Now my next questions go to Mr. Burgess. Mr. Burgess is a colleague of yours at Aperture, correct?
Correct.
Are you aware of issues relating to the accuracy or inaccuracy of his CV?
Unfortunately, I've been bombarded with emails that have referenced that. I've seen it. I have not read them.
You've been bombarded with them, but you have, and you say unfortunately, but you have not read any of them? None?
Maybe 1 or 2 lines. For example, they come in, they're looking like legitimate business emails. And then I pull it up as a business email. I'm like, okay, I'm not supposed to do this. Court said I can't look at this.
Now, I want to go back to your slide presentation. I understand that you intend, subject to our objections to the court's ruling, you intend to present testimony with regard to your PowerPoint where you are going to elaborate on your 1231-38 to 1231-43 trigger 1162-2, and you're going to add to what has been in your presentation a verbal discussion with regard to Mr. Burgess's change that he made in his May 8th report with regard to the variance time window. Do I have that correct?
No, you don't. It's not based upon a verbal discussion. It's based upon his report.
Okay, so you're going to make, you propose, what you're intending to do is you want to add the change from Mr. Burgess's May 8th report to what you're going to testify to on your PowerPoint. Do I have that correct?
That is correct.
And the only reason you're going to testify with regard to altering the 1231-38 to 1231-43 window is because of what Mr. Burgess has done on May 8th. Is that correct?
It's better data. So I'm altering it and correcting it with better data that I've received from Mr. Burgess.
Right. But my point is, if it weren't for Mr. Burgess's change, you wouldn't be making any changes in your testimony, correct? It's only because of what Mr. Burgess did on May 8th. Is that correct?
Only from his report, correct.
Correct. So, and you understand, sir, that that change has significant effects on the very issues in this case with regard to the timeline and the collision you allege occurred, and comparing it to human volitional conduct of Mr. O'Keefe with regard to his manipulation of the phone. You understand the consequences of that change, do you, sir?
I do. I would disagree with your assertion that it's consequential. Again, my original data, which is in my PowerPoint and has not changed, that data
Well, if it's not consequential, why would you change it? Right while the trial's going on.
is still there. The timing was extremely close within the error of the measurements, which Mr. Burgess ultimately showed in his subsequent report that was within the variance associated with those timing devices.
I understand, but my point, sir, and I want to understand if I have it correct, is that is going to move the time that you assert the 1162-2 trigger occurred, correct?
Correct.
And you would agree that's a substantial change given the issues in this case when seconds matter, or do you think it's an insignificant change?
I wouldn't say it's insignificant. Again, I haven't modified my PowerPoint at all. I was happy with the data I had and satisfied with the data I had. Again, once presented as engineer would with better data, we use better data. I'm sorry. It brings it,
Voir, dear, let him finish.
Yeah.
it brings it closer in time to Ian Whiffin's last contact point data. But even if we don't have that, given what I knew about the variance in the cell phones, my time was still within that window anyway.
Sir, you've just answered my question, which is
Good.
you agree that it affects the timeline in the activity of Mr. Whiffin's report. You said brings it closer. Did I have your words correctly?
Correct. What I was concerned about was your word about significant change. It brings it closer. It doesn't necessarily bring it significantly closer.
You know darn right it means a significant difference for the defense. So don't act like 21 or 29 seconds is not a big deal for most people. It is a huge deal for this case. So
Original timeline was very close, within the range of the accuracy of those types of cell phones, infotainment system data. So even if I didn't have Mr. Burgess's subsequent report, the data is still within that time window.
Sir, isn't it a fact that with the variance of Mr. Burgess that you're now you want to testify to, that there is a change because your 1162.2 trigger 1231.38 to 1231.43, you know that there's a device lock event on the phone of Mr. O'Keefe after that time period. You understand that, correct?
So again, there's a window of plus minus on that. Technically, those timestamps on that are, as you indicated, again, it's literally, I wrote that on my slide. It includes my slide where I have that exact comment.
But my question, sir, is the change means now that with the Mr. Burgess variance moving, you now have part of the moving range that occurs after the device lock, whereas before your change, the device lock occurred after every bit of your range of 1162.2. I have that correct, don't I, sir?
You do.
Okay.
Okay, so
Your Honor,
that's it.
that's all I needed. Thank you.
All right, so we're going to bring the jury in. Are they outside the door? Awesome. You may as well stay right there.
all right, hold on. Let's go back a second. I want to go to that website of Aperture. Here we see this guy. They don't have a doctor in his name in the upper right. They say he's an executive VP. Then they call him doctor here. And you go on down through here. So he's qualified as an expert over 200 trials. So it goes on to say he's got a Bachelor of Science in Mechanical Engineering from Cal Polytech, San Luis Obispo, and a Master of Science in Biomedical Engineering from University of Southern California. His dissertation research focused on. Okay, so his dissertation, or does it talk about when he got his PhD, though? This looks very sloppy and unprofessional. You don't even say where you got your PhD. It says here, just looking at this one web location, you don't see it. You think it would be highlighted there in the narrative. You go here, and then it's like, oh, well, here it is, a PhD in biomechanical engineering. But it doesn't say what university it came from. So that's really disjointed. And it doesn't say the year. Doesn't say the month or the year. Okay, maybe the month is not a big deal, but you don't have the years for any of this. That's really odd. Then you go to his CV. Not for expert designation. So I guess people should not use this for court purposes. But again, okay, here's the first time you see he's got a PhD from Southern Cal. But it doesn't say the year. It doesn't say the year that he got his master's. It doesn't say the year he got his bachelor's. It's just, I think it's very odd. To me, that's a red flag. If somebody doesn't put in the year that they got a degree, and I'm not disputing this guy doesn't have a degree at all. I'm just saying this is a very strange resume. So again, they have PhD up here with his name, but yet they don't on the main page. So let's see here. I'm not going to go to his LinkedIn account, but it just looks very weird that we don't see when he got his PhD. And you have to go to the third location to see where it actually got his PhD from. So I would say that's his most valuable credential, and that's sort of like buried in a lot of this. So it just is very strange. All right, so let's continue on here. We have I'm going to show the first couple minutes of his direct testimony before I jump to some of the other substantive stuff. Another day, none of the jurors have heard anything about this case walking out of the courtroom, and being away for a 5-day weekend just never came up in any place they've been in public or private. She's not even looking at all the faces to see their acknowledgement. Oh, sorry. Sorry, I'm not sharing the screen. My bad. Here we go. That's the wrong one.
The human anatomy. When I'm trying to explain to somebody what I do, I say, hey, it's like a civil engineer who's designing a bridge. So many trucks and cars on the bridge. Are that going to cause the beams in the bridge to fail? Is that going to cause the cables to fail? So a human body is governed by the same laws of physics, just like the bridge. Obviously, it's made of a lot of different materials, but in a human body, my beams are bones. My cables are the muscles and ligaments. Different material properties, but everything's governed by the laws of physics and principles of engineering. So I'm looking at how physical forces, the outside of the car, when people are inside the car, seatbelts, airbags. The first seatbelt was patented by an engineer. It's engineers who quantify the force of the crash and what kind of injury damage there is to the body. So it is force that causes damage like a fracture. And so we're looking at how the physical forces are applied to the body and what that means in terms of what happens to the body.
Dr. Welcher, I want to ask you a little bit about how you became a biomechanical engineer and an accident reconstructionist.
That's true. I remember this, Michael L. You're saying Brennan told the court that the changes were brought about by the ARCCA testing, and yet Welcher said it was done because changes by Whiffen and Burgess. So yeah, just another spin move there.
Can you tell us?
Sure. So when I was getting ready to go to college, my father, who was a physician, said, whatever you do, do not go to medical school. Because I was getting ready to go to medical school. So this was 39 years ago, I believe. 35 years ago. 39 years ago.
Why would he bring that up? That's really bizarre. Does he have like a complex that he didn't become an MD and his dad told him do not become an MD? Why would your dad tell you that?
He said, it's just not worth it. So I said, okay. So then I entered into the mechanical engineering.
But he made a career out of it. He didn't change careers. Why would he try to prevent you from doing that? So there's something going on here. Why would you bring this up? He never says I wanted to be a doctor because I wanted to help people.
I grew up riding motorcycles, taking things apart, frequently pissing my parents off when I couldn't put it back together. But I like taking things apart and figuring out
That's not very professional there.
how things worked. So I went to university and got my undergraduate degree in mechanical engineering. From there, I happened to be at a Thursday meeting of the American Society of Mechanical Engineers. A group came in from a company that did this type of work, and they showed some examples of how you apply engineering concepts that you learn in mechanical engineering to the human body. And so I was like, man, that's a great job. That's the perfect mix of engineering that I have and my desire, to learn the medical side of things as well without becoming a doctor. So I talked to them. I actually applied to the company and was ultimately hired as a biomechanical.
What is going on here?
Engineer.
How long did you continue as a biomechanical engineer until you went back to school?
So I actually very quickly after I started the job, I took a human anatomy class at a community college. I quickly realized that wasn't enough. And so in around 1993, I went to the USC Medical School and enrolled through what's called concurrent enrollment, which means you can take the class.
Yeah, so think about it. Brennan, along with his sidekick, Tully, and then Jen McCabe, think how much influence they've done on this case. And we also had Brian Albert that showed up at convenient times.
Class, but you're not actually in medical school. It's a medical school class. But I took gross human anatomy. So it was me and 160 or so other doctors. I took the same human anatomy that first year medical students at USC took. So it began in 1993.
Did you continue to work as you pursued your higher education?
I ultimately started my own company, continued to work, continued to do research, had a wonderful opportunity to have two beautiful children, and continue to this day.
Tell us a little bit about the company you started and when.
Sure. So in about October of 1994, I started my own company. Me and the guy who was my immediate supervisor said, hey, we can do this better. We can do more research, more testing. And so we started our own company.
What kind of company was it?
It was action.
Do more research, more testing. What about making more money? Working for insurance companies?
Construction and biomechanical engineering company. We also early on did a bunch of testing and design work for amusement park rides. The same concepts for car crashes applies to roller coasters, basically anything. So we worked and had some contracts on improving ride safety. And I was also on the ASTM committee that looked at amusement park ride designs.
Did that company grow from 2 people?
Correct. We took it from 2 to about 25 people.
No. LESB, they should be asking for all these witnesses that the Commonwealth hires, how much they're being paid. So they're definitely going to do that for ARCCA. The prosecutors do that for ARCCA. So I've been disappointed the defense has not brought that out better.
And then we ultimately sold it in right around January 1st of 2022.
Before 2022, did you obtain a master's degree?
And now they've also sold out again. So, and there's been other mergers and acquisitions of different types. So anyway, this is definitely like if you got a law practice, you have to make money. You can't just be doing the work you like. There has to be a money component of it. That's what pays the bills. So it's just not a matter of doing this kind of consulting. It's a money making business. So, and that's why he was able to make probably a lot of money by selling this, and they probably had him hired to stay on for a certain number of years. So anyway, notice also you'll see on his slides, he always has Aperture listed on the slides as like the heading.
I did.
And what was that in and where was that from?
So again, I was working full time. Actually, while I was doing my master's degree, I was also teaching classes at Texas A&M through their law enforcement training division. So it was extension classes. But I ultimately completed my master's thesis in December of 2001. That was from U.S.
Yeah, why is he looking down? Describe his experience.
USC, University of Southern California, and I received my master's degree in biomedical engineering. I wrote my thesis. It was basically on automotive seat design, but it was titled Whiplash-Associated Disorders, Related Anatomy, Biomechanics of Injury, and the Relationship Between Injury Potential and Automotive Seat Design.
Pardon the interruption. If Dr. Welcher reads from this report, which I think he just did, can we know when he's doing that?
Sure. Dr. Welcher asked me if he could refer to his resume, and I said yes. So if you read, just let us.
Thank you.
Yeah, he asked that directly to the judge, not waiting for attorneys to direct him and instruct him on that. That's a pretty bold move there. Talking directly to the judge. He's testified 200 times. He just feels at ease to start talking to the judge like that. I've never seen anybody do that before.
And it's my resume, not my report.
Your resume, did I say?
No, you did. He said report.
Yeah, no, it's his resume.
You share with us that your company continued to grow until you ultimately sold it in 2022. During that time, did you continue to pursue higher education after you obtained your master's degree?
I did. So again, ever since 1993, I've been slowly pursuing higher education, both obtaining my master's degree as well as my PhD. During that time frame, I also published 20 peer-reviewed scientific publications. I taught for 5 years at Texas A&M and served as a peer reviewer for both the Society of Automotive Engineers and for a short period on the Archives of Physical Medicine. So I was working and running a company with my co-creator, as well as teaching, conducting research, publishing, also while going to school part-time.
Take us to 2011. Were you still pursuing education at the University of Southern California?
I was.
And what occurred? What did you achieve in 2011?
So in August of 2011, I finally obtained my PhD in biomedical engineering. I wrote my dissertation, reading from my resume, titled Development, Validation, and Testing of a New Sensor Array for Intra-Articular Pressure Measurement, in vitro human lumbar spine, intra-articular facet testing, which is a lot of big words to say. I was testing cadaver spines, looking at the loads inside the spines
I'm
associated
going to
with.
jump ahead. So that's some of his intro of his background. And the one thing about this guy is he talked about how he looked at all the prosecution evidence, even talked about listening to a statement given by Karen Reed. So I just thought this guy is like really risking confirmation bias, and it's going to show up in his work. Let me jump to 514.
All right, Mr. Brennan.
Thank you, Ron.
We testified biomechanical is a subset of biomedical. So that's how those two things interplay.
Dr. Welcher, when we left off, you had given us your opinion on this slide. Could we proceed to slide 35, please?
Slide 35.
I believe the next slide is 35. Okay. Now, when we look at this slide, I'm going to ask you to zoom in, and if we can start from left to right, and we can identify each category as you discuss it and explain to us the importance of the columns.
So we already touched on this from left to right. The first column is the continuous running clock. Second column is where I converted it to minute and seconds. You can see we're on trigger 1162.2. This is the second trigger. The particular boxes that are highlighted are where there's change. For example,
what he does for most of the days, he's going through a lot of this vehicle data and also covers the phone data. It's sort of like a repeat of Whiffins, and that's why I think it's important to skip all that.
in the upper right, when you're transitioning from drive to neutral to reverse. And then I already discussed this a little bit, but where the wheel's slipping, you can see you have high acceleration pedal application, increase in the RPMs. But when you look at the effects on the vehicle, you can see that it's accelerating less. So that's indicative of slippage of the wheels. And then I simply show at the bottom the math I use to derive all that. So again, we touched on most of this. It's the same slide you saw before, just to show how corrected for the speed.
If you could zoom in for a second, I want to ask you a question about the RPM column.
RPM column, go ahead.
If you could zoom in.
Oops.
You see in the last line, the last piece of data captured, the RPMs changed from 3,200 to 3,300.
Correct.
And the accelerators is, it's fair to say, is that depressed? What's the way you characterize that?
Sustained.
How would you characterize 74? What does that mean?
I mean, it's 3/4 of full throttle. It's 74% of full throttle.
If above it's 74.5, it drops to 73.5 and then back to 74. Why is the RPM higher than above?
So there's, again, this data is referred to as being asynchronous. You're reporting it at particular times, but the computer's scanning the network for the data. So it's not all on exactly the same time step. Not only that, but there's frequently, I'm sorry.
Look at how he's sitting there. It reminds you of Sergeant Buchanan, just relaxing, elbows up, not having professional posture here in the court of law. There's a murder case. Not looking good.
There frequently is a delay from when you step on the accelerator pedal to when that translates to increased RPM at the engine. It takes a little time to build it up or take it down.
Okay, thank you.
You're welcome. So similar to what we did on the first one, basically what we did is we took all the text stream data that we had, which includes the shifting, the forward, the reverse, and the steering. Again, there was a tiny bit of leftward steer, and put that into a simulation program where we're simulating what the Lexus will do. So we've taken into account the mechanical characteristics, the steering response to the Lexus. So this is to show what it represents on the left-hand side. So each one of these little hash marks, a different color, represents 10 feet. The red lines show the extent of motion. Remember what I said, initially pulled forward, then backed up, past its initial spot, and then went backwards further distance. So what this shows is where we simulated this in a program called HVE. So that's the vehicle, the Lexus pulling forward. And then it accelerated in reverse, past its initial starting position, and came to rest right there.
Doctor, when you say it came to rest there, do you
I'm
have
sorry.
data that the that the defendant's Lexus stopped there?
No, it did not come to rest. That I misspoke. That's where the text stream data ends. As you can,
Where's that in relation to 34 Fairview? I mean, you got two diagrams there. And let me back that up. So this is a top-down view. It's like 34 Fairview is the third house on the left from sort of like a T intersection, third house down. As you can sort of see a red arrow, it looks like, for that house. But this whole diagram on left every 10 feet, and it's just like it's not even a real video of a vehicle backing up. It's just all this thing that he's saying is coming from the car.
and then it
Data
accelerated
recorders.
in reverse past its initial starting position. And
All right, that doesn't look very fast there from that little diagram.
that's the vehicle, the Lexus pulling forward.
Goes forward and then back.
And then it accelerated in reverse past its initial starting position.
See, right there, that's misrepresentation, because even on this scale here, that's not going very fast. And look that's not very many car lengths. So within 7-8 car lengths, you can go 28 miles an hour on a snowy, cold night. I don't buy it. This is like really very misleading. I don't know why there wasn't an objection to this. It's just not to scale. It's very misleading. He's making it sound like absolutely this is what happened. And that is not to scale for speed, representing the size of that vehicle in terms of speed. So it's making the jury thinks 24 miles an hour is really not that fast, when it really is fast when you're in a vehicle. And he never talks about what a car like this can do in reverse in those kind of slick conditions. Is there some kind of safety mechanism that prevents it from accelerating, going that fast when there's not good traction on the road? That's what I'm hearing folks say about this Lexus.
And came to rest right there.
Doctor, when you say it came to rest there, do you
I'm
have
sorry.
data that the defendant's Lexus stopped there?
No, it did not come to rest. That I misspoke. That's where the text stream data ends. As you can see here, it's still going. It's still going approximately 23 miles an hour when that ends. God damn it.
You'll have to zoom in on that so the jury can see what you're referring to. Please.
So again, as I mentioned, the text stream's taking a window of data. It doesn't take anything outside the window. You can see that when we account for the wheel slippage, that the vehicle at the time of the last data point, again, is at 74% throttle, 3,300 revolutions per minute, and is going backwards approximately 23.9 miles per hour. And you can see it's traveled a total distance backwards of 53 feet back from where it initially started. Or if you consider where it pulled forward 34 feet and then backed up 53 feet, add those two together from the point it pulled all the way forward.
Okay, but in the opening, Hank was talking about 72 feet or 73 feet is what Karen backed up. So that's changed again as well. What about Higgins Jeep?
So this is
I agree.
10, 20, 35 forward. And then I'll go 10, 20, 30, 40, 53 back for a total of 87 feet. So from the maximum point I pulled forward to where it backed up, again, that was 34 feet forward then a total of 53 back, total travel distance of 87 feet. So went all the way forward where it stopped, it then backed up 87 feet. And when the tech stream data stopped,
Thanks, Donna.
it's still moving. It's still moving about 23 miles an hour, and you're still at 74% throttle and 3,300 revolutions per minute on the tachometer, RPM gauge.
They act like this data is ironclad, rock solid. I don't trust this car data at all. I've heard too many stories of electronic stuff on vehicles going haywire and not being accurate, and cars breaking down, and the car dealership will say there's nothing wrong with the car. So this stuff is sort of like out there.
We could turn the light on for a moment. Dr. Welcher, in your analysis of the data and the information you acquired and the evidence that you relied upon, did you come to some conclusions and opinions regarding the defendant's Lexus that evening?
I did.
As part of that opinion, you mentioned that you considered mileage to map distances as one way of mapping the location of the vehicle.
Okay, so yeah, so like you're saying, where did the Lexus wind up? Queen Olive Ruth Ann. So he goes into great detail talking about how the interaction between Karen's vehicle and John O'Keefe's when she was backing up, and where she tapped into his vehicle. But there's none of this kind of detail showing exactly where Karen's vehicle was on the street, where John was. None of that comes out in this at all.
Remember that?
I do.
If you could provide us with slide. I believe it's slide 25. And could you widen the left-hand box a little bit? And you mentioned you measured or you ran information about distances between different routes,
Correct.
specifically regarding Fairview to Meadows, the first box. Do you see that?
I do.
There are 3 different mileage numbers.
Yes.
And then there's streets to the left. Can you explain what's set out in that box?
Sure. That's basically 3 different routes you can go. Sherman Street, Pleasant Street, Washington, and Sherman Street.
All right, I don't need to.
When you considered the shortest route, 2.3 miles on Sherman, and what did you make a determination on that distance in that
Correct.
time? Opinion, to a reasonable degree of engineering certainty, how many triggering events occurred? How many triggering events occurred in that ignition cycle 1162?
Objection, Your Honor.
I'm going to allow that.
In 1162, the tech stream recorded 2 triggering events.
And do you have an opinion as to the type of triggering event, the type of movement of the defendant's Lexus in those 2 triggering events?
I do.
Regarding the first triggering event, 1162-1, do you have an opinion to a reasonable degree of engineering certainty what type of event the first triggering event was?
Objection, Your Honor.
I'm going to allow that.
The actual trigger was excessive rearward acceleration. The event was during the course of a 3-point turn.
And do you have an opinion to a reasonable degree of engineering certainty the time between triggering event 1 and triggering event 2 in that cycle 1162?
Yes.
I think the jury's just so their eyes are glazed over with this stuff. I just think that they can't be trusting Brennan, and hearing Brennan's name keep coming up with getting stuff to change during the middle of the trial to get the numbers lined up. How can you trust a guy like this? And then he calls this guy in here and he's changing his opinions as well. They got to get their story straight.
And could you share with the jury your opinion to a reasonable degree of engineering certainty the time between those 2 triggering events?
Approximately 8 minutes and 5 seconds.
Do you have an opinion to a reasonable degree of engineering certainty as to the type and triggering event of the second event, 1162-2?
I do.
And could you share with the jury your opinion to a reasonable degree of engineering certainty, the type of event to that second triggering event?
I'm going to allow it.
Everything's
It's-
allowed.
Again,
You want.
the trigger event itself was a transition into reverse and then high throttle application. It's a forward motion followed by a lengthy high-speed rear impact or rear motion.
Oh, rear impact. See, there he slips up. Rear impact. That's part of his bias, confirmation bias, because he read the whole file. He read police reports. He's looked at photos, all the botched evidence collection procedures. He's seen different photos days, weeks later after stuff is found. So he's already bought into being part of the prosecution team. And that's a slip up right there. He called it high-speed rear impact. Okay, if she's going so fast, where does she wind up? You know, we heard about Higgins' vehicle right there at the mailbox from some folks in the house. Where's Higgins' Jeep at? And had a blade on the front of it, a snowplow blade. So if you're going that fast and then you're going to hit the brakes, you're going to go sliding for a long distance. You're totally out of control. You're going to smash into other cars, the mailbox. So this is just really unbelievable type of testimony. This guy is supposed to be an expert in this. He doesn't sound like it. Just very flippant and not precision engineering that I see here at all. Let's keep watching.
Strike that portion of the answer.
Yes, I'm not going to highlight it.
I
So
appreciate that.
get the answer again.
Would you like me to ask the question again, Your Honor?
Yes, Mr. Lessie, yes, right? I'll strike the previous answer. Go ahead and ask the question again.
Okay. Do you have an opinion to a reasonable degree of engineering certainty as to the nature of the second triggering event, 1162-2?
Just for the record, Your Honor.
Yes.
Could you share your opinion with the jury?
The triggering event was high throttle opening in a transition to reverse. It's a forward motion followed by a higher speed rear motion. And at the end of the trigger event, you're still at 74% throttle.
Do you have an opinion to a reasonable degree of engineering certainty, the entire distance captured in that 10-second window during the back maneuver or 1162-2?
Do I have an opinion about it?
Do you have an opinion to a reasonable degree of engineering certainty about
Yes.
the entire distance that is captured in that 10-second window of the second triggering event, 1162-2?
So it obviously only captures what's going on during the trigger. It doesn't capture before or after the trigger.
Understood. Do you have an opinion as to just what is captured as far as the distance?
Yes,
And what is your opinion?
that it's 87 feet. So again, the initial forward motion is 34 feet, followed by it backing, crossing the initial point, and then backing up an additional 53 feet.
And finally, regarding this part of your analysis, do you have an opinion to a reasonable degree of engineering certainty as to whether the defendant's Lexus was decelerating, accelerating, or remaining the same at the end of that data captured at the triggering event 1162-2?
It was accelerating at 74% throttle.
In addition to your analysis of the tech stream data,
You know, notice what they didn't cover is where other vehicles were that night. So why aren't they talking about that? The location of other vehicles. What about the mailbox they would have hit? They're not talking about the curvature of the road, the ability to drive and reverse that fast, safety devices on the car, accident avoidance things, and all that kind of stuff. He knows so much about these Lexuses, but he's not talking about any of that. So how convenient.
one final question. Do you have an opinion to a reasonable degree of engineering certainty the relative time this backing maneuver occurred with the defendant's Lexus that you just spoke about?
Yes,
And could you share with the jury your opinion to a reasonable degree of engineering certainty?
sure. It matches the window of the cell phone data for Mr. O'Keefe that puts it in front of 34 Fairview.
How's this guy an expert on cell phone data? So he knows car data, he knows cell phone data. What are his qualifications for that?
So the backing event occurred somewhere between 12:32:04 and 12:32:12. The
Sir, and
end
I
of the
want to
event.
turn to a different part of your study of this case.
Okay.
At some point, did you try to determine whether there was an intervening event that could have caused damage to the defendant's right rear taillight separate from a collision at Fairview?
I did.
Objection, Your Honor.
So the form of the question is to.
Yeah, let's go back.
Taillight, determine whether there was an intervening event that could have caused damage to the defendant's right rear taillight separate from a collision at Fairview.
I did.
Okay, right there, he's saying there's a collision at Fairview, and what he's trying to do is get back to this issue of John O'Keefe's vehicle and whether the Karen backing out could have also, that could have been the cause of her broken tail light.
Did.
Objection, Your Honor.
So the form of the question is to Brennan.
Okay. At some point, when you looked at the data and analyzed this case, did you consider including or excluding evidence?
I mean, you've heard all this key stuff. You've heard it from Whiffen. You've heard it from Burgess. Now you're hearing from this guy. I mean, Brennan doesn't understand. The jury's like saturated with this kind of minutia. They're tired of it. It's just data overload. Their hard drives are crashing. They're tired of this stuff. And these guys just sit there all relaxed, one after the other, just going on and on ad nauseum about this kind of stuff. The jury's sick of it.
Or did you analyze evidence to reach a conclusion, including or excluding whether there was an intervening event that caused damage to the defendant's Lexus right rear taillight?
Yes, I did.
When you started your analysis, what information or claim or evidence did you become aware of that you want to analyze to include or exclude as the cause of that damage?
Sure. So my approach to this case is three prongs. I'm looking at the downloads, the technical information. I'm looking at this backing incident, and then I'm looking at Mr. O'Keefe's injuries and how they relate to the events, potentially. So the second prong, which is looking at this data. So I had a Ring doorbell video showing Miss Reed backing the Lexus out of Mr. O'Keefe's residence at approximately 5 o'clock in the morning. And so we wanted to look at the backing activity and whether that contacting Mr. O'Keefe's vehicle, whether that was sufficient to cause or what damage it could cause, and particularly was it sufficient to cause damage to the right rear tail light of the Lexus.
When you were asked to engage in the study, were you ever asked to reach a certain conclusion?
Never.
Was there ever any influence other than the data and facts on your analysis?
There's never been any influence. The influence, again, it's whatever the data shows.
When you engage in whatever study,
But there's also motive. Keep in mind, if he had the same opinion as ARCCA, he's not going to be called as the witness. He's not going to make all this extra expert fees, flying up there, sitting around for days, sitting around for rebuttal. So his firm is making a whole lot more money by having a different opinion than ARCCA.
studies you undertook that you'll explain to the jury, were you given any direction or limitations on what you could or should do?
No.
So in other words, whatever it costs to run the test, money was no object. There's no limitations on money. That's why they're able to buy a Lexus in Texas and have it trucked all the way out to LA area so this guy could look at it. Money was no concern to go after Karen Reed.
When you received the information, did you understand, regardless of the result, it would be provided to everybody?
I guess generally, yes. I mean, I go through the data, I give you the results, you do with them whatever you see fit.
And in this case, when you decided to engage in that study, had you had an opportunity to review the ring video footage from Mr. O'Keefe's home on the morning of January 29th, 2022?
Yes.
Tell us how you went through your study, how you began, and the steps you took, please.
Sure. Probably best on the slides. So one of the things we first did was to get an exemplar Lexus. What does exemplar mean? It just means I got the same exact year, make, and model vehicle as Miss Reed. So Miss Reed's vehicle is on the left-hand side, taken during my inspection. And then I found this exact same year, make, model, manufactured at the same plant, everything Lexus in Texas. So even though it looks like a European plate, it's a Texas plate. Purchased the vehicle, had it shipped out to California. So I verified that the
We don't have white plates like European plates here in Texas. What's he talking about?
Lexus is in fact the one I got, the same exact one as Miss Reed's. These are all the standard equipment. Miss Reed's is on the left. My exemplar is on the right. It says Reed Lexus TIS, that's Toyota Information Services, Toyota Information System. So I ran it through TIS, which is the umbrella program under which TechStream runs. I also ran it through My Lexus, which is the Lexus website. And then started about doing what's referred to as a photogrammetric analysis of the video.
Can you explain to us what a photogrammetric, help me with the word, photogrammetry?
Photogrammatic. We're doing photogrammetry is a photogrammetric analysis.
What does that mean?
It's just a big fancy word to saying you're looking at data and photographs. And what we're trying to do is take two-dimensional images, say you get from video or photographs, and knowing some information about the photographs and some of the dimensions of things in the image, get or convert it to a three-dimensional space. In other words, be able to get exact three-dimensional measurements out of that two-dimensional
Pardon
image.
me, speed up.
So I had the video, just to show the provided video that I was given. So Mr. O'Keefe's vehicle. I don't know if you noticed, but there actually is contact between the vehicles. So one of the first things we wanted to do is determine the frame rate, which is how many video frames are played per second. Your normal kind of video camera has about 30 frames per second. Your standard movie is 25 frames a second. You know, a modern IMAX is like 60 frames a second. The frame rate of the camera, how many images it shows per second, because video and films are just single images played really fast. So it looks like motion. And so determining the time between each frame tells you how much time occurred. So if we know the time between each frame, and then we can figure out how far the vehicle moved, distance divided by time is speed. So we put it through a couple different programs. This is called AMP5. We got 19 frames a second. This is a specific forensic program called Axon Investigate, 19.8 frames a second. This is a publicly available program called FFMS. Same thing, 19.8 frames a second. Another program, Media Info, 19.8 frames a second. Anyways, 5 different sources, we're getting 19.8 frames a second. So then what we've done is add information now. So now that we know how many seconds each frame represents, we now put a clock back in to tie that into time. So it's the same exact video, except we have a frame counter now, and we have a time. So we have some information now on the time between each frame. So here's frame 0. This is frame 265. We're 13 seconds into it. Here's frame 305. Notice you see brake lights on the back wall here. Notice how they're not super red because you still have reverse lights on. Now they all go off. So the Lexus brake lights have been turned off at frame 353. 356.
Looks really red on both sides, unless some of the brake lights or reverse lights are on. It looks very red there.
Lexus brake lights begin to come on. 357, they're back on. Lexus comes to a complete stop at frame 369. 384, the reverse lights turn off. So now look how red this is because we no longer have the white reverse lights in it. And you can see the Lexus starts to drive forward. So frame 825, this is after the Lexus has left the scene. But notice the tracks in the snow. So we have very definitive locations for the wheels of the Lexus. We lay over a grid on the various frames. So we then took the images and did what's called clarification, which is where you overlay images from multiple versions or multiple views of the same vehicle, and it helps sharpen the image, but it slightly dulls the color. So you get a little cleaner, crisper image. So here's Mr. O'Keefe's vehicle before clarification, after clarification.
Excuse me, Your Honor, pardon my interruption. Can you get numbers of the slides as we're toggling back and forth?
Sure.
Absolutely. Okay, I'll make an effort. So slide 76. You're welcome. Going to slide 77. We're going to focus in on this area here. So what we will actually show is where the snow was displaced in these two spots, spots right across from here and right across from here. You could focus your attention on those. Slide 77. So slide 78. To bring us all together, we went out to Mr. O'Keefe's residence and took a scan, a laser scan. So you see the laser scanner over here. Laser scanner is right here. Fence.
So funny, he's doing all this laser work there at One Meadows, but he's not doing any of that for 34 Fairview.
Hasn't changed position. The camera's changed slight position. We can account for that. So here's the subject.
Granted, they didn't have any Ring video camera footage there, but they're not doing anything to lay out where exactly Karen Reed's car went when it supposedly would have struck John O'Keefe. They just don't have any of those kind of details.
Video, we have the correct resolution. There's a new camera. It's going slightly faster frame rate. That just means we have different times between frames on the new camera, but we're simply using it for calibration to the old camera. It's the same container for the MP4, and it's using the same video codec. Video codec is how the computer encodes the video.
That's slide number.
Oh, yes, thank you, Your Honor. Slide 79. Slide 79, part 2. So really, we care most about is the resolution. So slide 80, you can see these are what are called control points. So from the laser scan, we locate these various points. So the 3D scanner knows the exact position of all these points on slide 80 in the image. And so what we can do is use this information in conjunction with the video to create a scaled version of the video. So when we have three-dimensional images or three-dimensional measurements, we can then use that to give us some three-dimensional information from our 2D video. So there's the points on slide 81. Slide 82, excuse me, slide 81, second part, we're basically just fading in. So what you see now, if I go back to the beginning of slide 81, this is the picture from the video camera. And then what you see here is, which is barely any difference, and that's because what we've done is we've now overlaid the points from the laser scan. So now each one of these little speckly points, we know the exact 3D coordinates of those. So we can now know the exact position of all these fence posts, all the positions on the driveway, and we can use that to calibrate. Going to slide 82.
Yeah, he's not talked about that at all in this Lexus.
So using that information, it's called solving for the camera. We verify that we have appropriate residuals, meaning we don't have too much error. Slide 83. Okay, subject video. Then this is the subject video with the control points overlaid on it. That's a subject video where we're phasing in the laser scans of the scene, 84. So this is both on slide 84. I'm just toggling between the point cloud and the video. And what I'm trying to illustrate is how well we were able to overlay the point cloud onto the video data. So for example, if you say watch one of these fence post points up here while I toggle between the video. There's a laser scan, there's the video. So we've done a good job. Again, the residuals show that we've done an adequate job of matching the data. Slide 85. So what I'm doing here is toggling between, this is the video of the car. Remember I told you I went out and I inspected Mr. O'Keefe's vehicle and did a laser scan of it? So we're now taking that laser scan of the video, or excuse me, of the vehicle, and overlaying it onto the car in the video. So this is the video image. That's the laser scan laid on top of it. So we know all the dimensions in the laser scan. We know all the dimensions in the scene of this.
Yeah, and who's to say any of this equipment is accurate and reliable and trustworthy to be used in court?
We have the tire tracks. We can create and take data points along the tire tracks, create a map of those. So green is the right rear. Again, the vehicle's backing out, coming, slide 87, coming out this direction, backing here, stopping, pulling forward towards the bottom of the screen. Backing out here, pulling forward like here. Slide 88. So this is the Lexus lined up. This is when the Lexus has come to a complete stop. This would be maximum engagement.
Okay, now show the whole
Again, this is just
movement
toggling
forward.
frame 88, showing that we have the time and frame number. 369 on the same slide. We've now overlaid the Lexus laser scans on top of the image of the Lexus. So there's the video image, a still image that we took from the video. And here's where we overlay the laser scan of the Lexus. So we've overlaid the laser scan of the Lexus onto the Lexus. We've overlaid the laser scan of the Chevrolet onto the Chevrolet. And we've overlaid the laser scan of the scene onto the scene.
Yeah, but the full dimensions of the vehicle, for example, Karen's vehicle, how do you have the full dimensions of what the rear end looks like? You're telling me that computer can calculate all that and figure out exactly where they would touch?
So now what that allows us to do, we now know the position of everything in there. And we've also tracked the position of the tire tracks. So that's what it looks like if you overlay the computer model of Ms. Reed's vehicle onto the tire tracks.
Slide over.
Oh, my apologies, Your Honor. Slide 89. And then I'm just toggling slide 89 where I turn the vehicle off so you can see how the tire positions match up. Another toggle of slide 89, how the tire positions line up with where the end of the snow was. From all that information, again, we lined it up in the video, we lined it up in the scene, we have the two vehicles. We can get the exact position of the vehicles when that Lexus stopped. So when that Lexus stopped, that's going to be the maximum engagement. So from that information, we can get the angle of the vehicle. We can get the degree of overlap, the impact configuration. And it's hard to see because of the angles and because these vehicles are not at right angles to each other, the exact contact. Now I mentioned, and we're on slide 94 now, that contact on the rear of the Chevy Traverse. So you can see we actually, and you can't see.
I mean, he's making it look like Karen's SUV backed into the middle part of John's Traverse, and that's not what we saw in the video here. It looked like corner to corner.
So we took a whole bunch of data points within those two areas where the snow got dislodged, and we're looking at where that is. So if you look at that on the vehicle, so this is where it is on the rear of Mr. O'Keefe's Chevrolet. You can see it's about 25 and a half inches above ground, 32 and a half inches above ground. Here's Mr. O'Keefe's vehicle. So these marks are kind of, this is the Chevy Traverse words, are approximately right here. Again, I had the opportunity to inspect Mr. O'Keefe's vehicle. There's no damage. where these marks are. So sure, it knocked the snow off, but it wasn't sufficient to cause damage to his vehicle. We then mapped that data onto Miss Reed's vehicle to look at where that height is. So you can see the only contact marks are down at the bumper level. I mentioned how that bumper sticks out. This is exactly where you'd expect it. So the only evidence of contact is nowhere near the upper taillight. I emphasize the word upper taillight because it is right in line with the lower taillight, but yet the lower taillight also was not broken. So again, 25 and a half, that's 24 right here, 25 and a half. That's 24 right here, 25, 25 and a half. That's right where that scuff mark was. It's also right at, again, the level at the top of that light. This light is not broken. I've looked at the front of it. I've looked at the back of it. I've looked all around it. It's not broken, and it sticks out further than the light above it. So using those positions, matching the overlay of the,
He doesn't show us when the video of the Karen driving forward, though. Why is that
of the vehicles,
kept out?
we can get the speeds from that. We know where the Lexus
You can tell it's mostly all red there. It's not all that smashed out.
is. We know how much time it is between each frame.
Like they're trying to make it look like it was at the Sally Port.
So we know how far it moved. And so what we know is that when it first came to a stop, right before that, it was going about 0.7 miles per hour. So realistically,
That's why a lot of this reconstruction stuff, it might be fine for civil cases, but for criminal cases, when you got somebody's life on the line and they just throw these images up there, say, oh yeah, this is exactly what happened. Well, what if it's garbage in, garbage out, and there's not correct data and they don't have the right 3D capture of what the vehicles are like? Surely there is some error in here. They talk about variants for all these phones and stuff like that. You're not telling me there's variants on these images as well?
somewhere between a half to 1 mile an hour, just to account for some variations, but definitely going 1 mile an hour or less at impact.
Slide over, please.
Oh, thank you, Your Honor. Slide 99. That's the dimensions. Slide 102. Similar to what I said, no damage to that light, no damage to Mr. O'Keefe's traverse in that area. And then if I could, I would like to go back because I realized I skipped over something.
That's why I'm showing that reverse, because you're right. He uses all this detailed stuff, all these drawings for this at One Meadows, but he doesn't do any of this for 34 Fairview. And that's what we really need to see. But
So this is slide 85.
they can't say with any credibility what happened, and that's why they're not doing it.
So this is Mr. O'Keefe's vehicle before contact. Huh. I don't know what happened this time. The slide shows that we had,
Okay, but I think Ellie, you said you have a different system than this guy's using. He's using it something else. So, but yeah, nothing's an exact science that cannot be altered and manipulated.
there was snow here, now there's no snow there.
Dr. Welcher, did you look on the driveway after the touching between the two cars to see if you could see anything on the snow at the back of Mr. O'Keefe's vehicle?
So referring to this slide, this is after the Lexus has pulled away. Looking in the snow, I see nothing in the snow.
Were you looking for anything in particular?
Of course I was. I was looking for taillight fragments.
In any of the videos that you have that show Mr. O'Keefe's vehicle after the defendant's Lexus touches it, do you ever see any remnants or shards or fragments of taillight on the ground?
I do not.
When you did your analysis and study, trying to include or exclude this touching as the source of damage to the defendant's Lexus rear right taillight, did you consider speed as part of that analysis?
I did.
Did
I
you?
consider speed, and then again, knowing we have the positions of the vehicle, we looked at the degree of overlap, and there's only about 2 to 3 millimeters of overlap between the vehicles, which is insufficient to cause the tail light that's recessed in from the edge on the right rear of the Lexus to contact the rear of the Chevrolet.
Considering all the data and analysis that you did you come to a conclusion to a reasonable degree of engineering certainty whether the right rear taillight?
He never explained how the right rear tail light had what the condition of it was. He just hold on a second.
Ms. Reed's Lexus was broken or damaged during the contact with Mr. O'Keefe's car at around 5:07 a.m. on January 29, 2022.
That impact did not break or crack that taillight.
Is that your opinion?
That's my opinion.
Is that to a reasonable degree of engineering certainty?
That's to a high degree of engineering certainty.
You mentioned there were 3 areas of study, and we've been through 2.
Correct.
Could you tell us what you focused on your 3rd area of study regarding this case?
So the third area of study, I'm now focusing in on the injuries, the at scene, physical evidence, taillight fragments, broken glass, things of that nature.
Here's a real crazy part. You guys got to see this.
Okay. And when you conducted your studies and reached conclusions, did you, in your PowerPoint, provide slides to help explain your process and inevitably your conclusions?
Yes, sir.
You can take us through the 3rd section of your efforts regarding this case, specifically your efforts to identify the different pieces of evidence and your conclusions about a collision in this case.
Absolutely. Slide 104.
Please.
So this is a,
You know, where's the video of Karen pulling ahead slowly after making that contact with John's Traverse? Where is that? Why aren't you playing this here? It's so misleading, and for this guy not to show the rest of that, that's the best view to see it. So we're supposed to take his word for it rather than us seeing the video, and he's doing all this laser enhancement and reconstruction. Why isn't he showing that?
Is this 105, Dr. Welcher?
I'm sorry, 105.
Here
Yes,
shows
sir.
the bias.
Slide 105. This is a picture of Mr. O'Keefe's right arm, forearm, hand, and wrist. In anatomy, your arm is defined from your shoulder to your elbow, and then from your elbow to your wrist is your forearm, and then this is your hand. So technically, when you say arm, it really means from your elbow to your shoulder. Most people call this whole thing arm. It's actually the upper extremity. Arm is from shoulder to elbow, elbow to wrist is forearm and hand. So you can see I wrote arm and forearm. So arm, elbow to shoulder, elbow to wrist is forearm. So looking at the injuries to Mr. O'Keefe's arm, forearm, as well as his hand. So
Look at
this is me. I'm actually 6 feet, half an inch tall. What you see in the upper right is the coroner's examination report for Mr. O'Keefe. He's 73 inches tall. That's 6 feet, 1 inch tall. At this time, I was 220 pounds. Mr. O'Keefe at the time of this incident was 216 pounds. So I took measurements of myself. I'm actually wearing the same make and size shoes as Mr. O'Keefe, the same brand of jeans as Mr. O'Keefe, the same brand and size shirt of Mr. O'Keefe. You see the Lexus.
This is really strange. I've never seen anything about accident reconstruction where somebody's actually trying to dress up like a murder victim. This is really creepy, I think.
In the background,
What do y'all think?
we have matched the height to the Lexus. What I'm showing here is both my height, and then keep in mind where the height of this wing is relative to my right eye. So now I'm wearing, in addition, the same shirt and shoes, same type of sweatshirt, and actually the same kind of baseball hat. We tried to determine the exact glass from the waterfall grill, found out they were getting different ones at different times, but I ordered my glass from the same distributor that Waterfall Grill ordered their glasses from. So you can see in my right hand here, I have a glass. Here's a glass. It looks similar. It's from the same location.
So you're dressing up as a murder victim and you're the expert? That's just really bizarre. Why wouldn't you have like a crash dummy? You said there's no restriction on what you could do, so you wanted to become like the stunt man for this?
And then in the lower right photograph, what I've done is I've rolled up my sleeve, taken the sweatshirt off, and I'm going to look at how this contact pattern lines up.
This is
So the first set of
bizarre.
slides, I'm simply standing next to the Lexus. We know we have a broken taillight. We know how scratches on Mr. O'Keefe's arm. I'm seeing how those may or may not relate to the height and position.
Okay, so right there, look at that. You're gonna take this guy's standing there and try to equate this to John O'Keefe. We don't even have it established that John O'Keefe, where he was at, where he was standing. This guy is automatically making the jury, by acting out and dressing as John O'Keefe, making the jury think this is what must have happened. This guy's an expert and he's dressing up as John O'Keefe and he seems to know everything and explaining everything. So this is highly prejudicial, inflammatory, because they're trying to recreate what happened using this guy as an expert to try to explain it. So it's just, I've just never seen this whacked out crazy. It's really bizarre. And if you look at his elbow here in his arm, it's like, where's all those rips going all the way up and down his arm at a horizontal level? So here, if that's his forearm there, think about it. His forearm is going to have, if that was broken, the forearm scratches would be linear down the arm, not perpendicular to the length of the arm. And then up here by his bicep and the side of his tricep, why would those also be then in the same linear fashion that we saw on John's arm as when it's in an elbow, when it's in a 90-degree angle? His whole arm is a 90-degree angle. So none of this is adding up, and he's just declaring this to be so. So watch this.
Of the taillight.
Dr. Welcher, if you could back up one slide, I have a question for you. In the middle photograph, at the top of the Lexus, there's like a rim. What do you call that?
I call it a wind wing. I mean, it could be a wing.
I think it's called like a visor or a spoiler, but a wing, no, I don't think they call it that. You think he would know? He's the car expert. I'm not, but I've never heard it be called what he's calling it.
Thank you.
Air dam would be another. Okay, so I then set about to do a little bit of testing with the Lexus. The first test you're going to see is me just walking backwards, or actually sideways, into the Lexus. What I've done is I've painted the Lexus right rear tail light with what's called grease paint. Kind of sort of like paint, but it doesn't dry. And then
What's also misleading is that John had his hoodie on. He didn't have this T-shirt. So why is this guy, if he is going to try to replicate what happened there, and he's allowed to do that, which I don't know why defense isn't objecting to all this, but he's going to be dressed differently, similar T-shirt that he had underneath his hoodie. But where's his hoodie? He should be having a hoodie like this if he's going to try to replicate it.
have backed up.
Remember the one with all those dog bite holes in it?
Sideways, side shuffled into the Lexus with my arm out, see what the damage pattern looks like, or basically where someone of Mr. O'Keefe's height's arm would contact the rear tail light. So then what you see is I've shown the photographs again. I show the paint transfer onto my arm, the yellow.
Okay. Well, what about the entire length of your arm? They had those those marks went all the way down the arm. They're all like in the same perpendicular alignment to the arm. So it's like the arm would have been straight and not at a 90-degree turn. So this guy is making his elbow at a 90-degree angle. How does that happen where this guy can come up with this? This is like I said in the title, it's like 5th grade type experiment, 5th grader level experiment.
Grease paint on my hand was to show where my hand would hit the taillight. And so just kind of me walking slowly sideways into it, the approximate location of
Walking slowly sideways into it. How's this recreating anything having to do with John O'Keefe? This is just like crazy, insane lunacy stuff here. Yeah, he's trying to program, but even if you have any common sense, you see this thing is just absolute quackery here.
the taillight, and I'll line it up with the broken taillight in a second, lines up with the approximate location of the lacerations on Mr. O'Keefe's arm.
Dr. Welcher,
So he just declares it so. He's not explaining everything. Where are these lacerations? How did the taillight break? So you're saying that before it broke, it's going to cause these lacerations? How would this polycarbonate taillight cause all those horizontal lines down the arm that look like dog bites or dog claw marks? This is this is how desperate the Commonwealth is.
let me ask you a question. When you're engaging in these demonstrations, are you attempting to try to show exactly how Mr. O'Keefe was struck?
I mean, I just can't believe a prosecutor would sit there and prop this kind of stuff up and want somebody convicted with this gimmick here. Yeah, that's right, Ryan B. They paid 60 grand for, I think it was like more like 70,000 for that Lexus, but couldn't get a stand-in for a reenactment. It's comical. Yeah, but except, it's so laughable. On the other hand, this is Karen's life on the line. So really, blue paint is how they're going to try to show the injuries on here. And he just declares, I got to go back and have you guys hear that again. This is so bizarre. This is like more bizarre than what Trooper Paul said John O'Keefe did about spinning 30 feet in the air to try to say this is how he hurt his arm, had all those marks on his arm.
Of the taillight, and I'll line it up with the broken taillight in a second, lines up with the approximate location of the lacerations on Mr. O'Keefe's arm.
So he's saying that before he's showing it. So this is unbelievable. Reenactments are very, very misleading, and that's why to have them in a criminal case, I've just not seen that before. It's very much there's such a high degree of prejudice to a jury, and so I'm just really baffled by all this. Yeah, this reminds me of Mythbusters, except Mythbusters actually had, credible experiments. This is like some kind of goofing around type thing somebody would do when they're drunk or something.
Dr. Welcher, let me ask you a question. When you're engaging in these demonstrations, are you attempting to try to show exactly how Mr. O'Keefe was struck?
No. So we don't know exactly how he was struck. And pedestrian impacts are extremely sensitive to exact angles. And so where exactly your foot is, whether your foot's off the ground, can have an effect on where you end up after that. We just don't have enough information in this case to determine all that information. We know the taillight was broken. We know the glass was broken. We know we have damage to the rear of the Lexus. We know we have lacerations in Mr. O'Keefe's arm. So I'm trying to see if there's any correlation between all those.
Well, can body posture?
So Yeah, but how do you know all that is tied together and done at the same time? How do you know that the glass was there? How do you know it wasn't planted there?
Just don't have enough information.
This guy looked at the police report and he's just trying to fill in all the gaps to make him have a cogent story and what happened. The problem is the physics and common sense blow up in their face every single time.
In this case to determine all that information. We know the taillight was broken. We know the glass was broken. We know we have damage to the rear of the Lexus. We know
we know. Yeah, that's what you're trying to do. Is confirmation bias. This is not the way engineers talk. Engineers are supposed to talk about objective stuff and saying, we know. You need to come across like an engineer. If you're an expert like this, he's coming across like he's a detective, an expert in all disciplines.
have lacerations in Mr. O'Keefe's arm. So I'm trying to see if there's any correlation between all those.
Well, can body posture on a clip or a side slight collision change the trajectory or the injury?
Yeah, I think this is also reversible error to have this kind of demonstration. It gets even better than this. So stay tuned here.
Of course.
Can the way somebody moves or reacts before impact change it?
Sustain.
What are other things that can change the trajectory of the person and the injuries?
So for example, if you get hit.
So they're just speculating. It's wild speculation. There's no actual, hey, doctor, exactly where was John O'Keefe's body? Exactly where was he hit? Where was he standing when he got hit? Where was the vehicle? Where in the street was this at? Show us the accident reconstruction. This is your accident reconstruction? Just be slapping blue paint around a back of a car and on your arm?
And knocked off balance or clipped and knocked off balance, you can take additional steps. That'll affect how far your body travels. If you have 1 foot on the ground versus the other foot on the ground, affects how the body rotates. If your arm is at 90 degrees or 85 degrees, will affect the kinematics. We attempted to model different possibilities, and we're getting results that were all over the map. Small changes in the pedestrian.
Yeah, because you don't have a story that adds up and makes any sense. It's all over the map. Yeah, there you just admitted it. It's all over the map. Why don't you show the rest of the car there at One Meadows?
Position gives you huge change in the output. And so from the tech stream data, we don't know exactly when in the tech stream data he was hit. So we don't even know the exact impact speed.
How does the tech stream data show he was hit? This is just a leap of faith. He can't prove it. He can't prove John O'Keefe was hit. And he's just outright there declaring it as if it already happened. So keep in mind, ARCCA, they could not testify that under no circumstances do they believe there's any way, shape, or form that John O'Keefe was hit by Karen's vehicle. And yet this guy's up there saying nothing about being consistent or not consistent. He's declaring it actually to have happened. So this is just something that he's just rambling on and he keeps going on about this kind of stuff. I don't know why he's allowed to do that. I mean, this is really bad for him to get away with this kind of stuff.
In most pedestrian reconstructions, you typically have a point where
I think he's hardly ever called for criminal cases because most criminals can't afford this kind of testimony and most rich people don't get prosecuted. So I think he's rarely ever testified in criminal cases. And I think he just is used to just running through all this kind of testimony and all these little charts and diagrams and not any consideration that really somebody's life is on the line.
the impact occurred, like where the person was, like in the crosswalk, for example, and they get hit and their tire leaves a rubber scrub. That's called the area of impact or point of impact. You then can look at how far they were thrown.
Yeah, you don't have any of that here. Talking about pedestrian strikes, yeah, in a parking lot or on a crosswalk of a street or something like that. That's totally something that's unrelated to what we got here.
And using some laws of physics, calculate how fast the car had to be going. Well, we don't have that in this case. We don't know exactly where Mr. O'Keefe was on the roadway when this happened. Sorry, I'm about to go to the next slide.
Yeah, see, reenactment stuff, that's like in civil cases, because there's not the prejudice that can attach to a defendant. And for him to go all the way to the point of saying this happened, the way he's phrasing it different ways, it's just something that's not allowed in criminal cases that I've ever seen. But I guess up in Massachusetts, we can have people get on the stand and say, yep, I think they did it. I think this defendant did it. I think she's guilty. You don't have to prove anything. You just have to believe that the person's guilty.
Without having an exact point of impact or an exact speed or an exact body position, are you able to specifically replicate the actual collision
Right
in
there.
the way Mr. O'Keefe's body would move?
Right there. You just let it all out there. Let it out of the bag, Hank. Look at this. We don't know exactly where Mr. O'Keefe was on the. Who's to say he's even on the roadway? Have you established that? It's all guesswork. They're just all speculating, wild speculation here.
When this happened. Sorry, I'm about to go to the next slide.
Without having an exact point of impact or an exact speed
They don't know any of this stuff.
or an exact body position,
You don't know know any position whatsoever. This guy just stood up there and rubbed some paint on his arm off of a Lexus, and that's supposed to be how it happened. None of the injuries line up.
are you able to specifically replicate the actual collision in the way Mr. O'Keefe's body would move?
Exactly replicate? No. And again, in terms of how
No, exact. We don't have to be exact, or we don't really have to prove anything. We just have to make wild speculation accusations. And you know what? We don't care about convicting somebody with just kind of wild speculation theories. No, heck, everybody gets paid and goes home except Karen Reed, but who cares? Due process doesn't apply. We're not concerned about the Constitution, presumption of innocence.
how he would move. Again, we don't know where exactly on the roadway he started. So in terms of how he moved, that's a function of where he started. We don't know if when he was clipped, he took an additional.
Right there. We don't know when he was clipped. So right there, he's declaring that he's guilty of being hit by Karen's car. Instead of the ARCCA experts, remember the ARCCA experts were limited. They could only say, because Lally had objected, they couldn't say, when Jackson asked them, they couldn't actually describe it as being, no, this didn't happen. Karen's car did not hit it. These injuries did not come from the car. They could only say, no, the injuries were not consistent with. So it just shows you how this judge is completely doing a 180 against the defense in the first trial. And here, because Brendan wants to bring this kind of evidence in, this kind of stuff is just going way beyond what anything I've ever seen or heard in a criminal trial. This is so much like in a civil trial mindset. It's just reversible error once again. Every day there's reversible error stuff that you see here.
Step before falling backwards. So that will change how far you are off the roadway. So the impact, which you'll see in a second, even at 2 miles an hour, will induce rotation of the body. So depending on the speed, the higher the speed, the more rotation.
Oh, now he's talking like some of Trooper Paul's language here. Rotation. Wow, this is like laughable. If not for the fact that it's Karen Reed's life on the line.
So slide 111, this is simply showing where
But keep in mind, Commonwealth knows they're going to lose the case if she gets convicted. They don't care. All they want to do is throw in the kitchen sink and then some to get her convicted.
walk sideways, how this lines up.
They'll always say she's the convicted one that got it overturned on a technicality.
With the location of the lacerations on Mr. O'Keefe's arm.
Oh, let's back up.
Here's the post-contact where if
How
when you'll
quick
see in
that was.
ends up.
Okay, I can't see anything and make anything out of that. So that little spot where the blue is, that's supposed to be John O'Keefe's arm and corresponding injuries. Where's the broken piece of plastic? How does this show anything? What's it talking
with the
about?
location of the lacerations on Mr. O'Keefe's arm.
Well, how did you get lacerations off of smooth plastic? Can you explain that, mister?
Depending on the speed, the higher the speed, the more rotation. So if I may,
So the faster somebody hits you, if you have your arm out, you could continually spin for 10, 20 revolutions and take off like a helicopter, like Trooper Paul was saying.
So slide 111, this is simply showing where I walk sideways, how this lines up with the
How does that line up? You rubbed your arm against a smooth vehicle as it's backing up 2 miles an hour against the tail light. How does that correspond to anything? Just because you rubbed your arm right there, so your arm like right there could have cracked the tail light. So think about it, folks. If his arm was like that, the position he showed on the Lexus, and you have a Lexus hitting you at 24 miles an hour, there's going to be massive bruising all where that blue area is. You don't see any bruising whatsoever. All you're going to see is scrapes. So think about this. You have tears in the skin from polycarb plastic piece of the tail light, but yet there's no bruising from the flesh that was bashed into the tail light to cause it to crack. So what kind of like bizarre theory are they thinking that the jury's going to fall for? If there's no bruises on John O'Keefe's arm and there's only scratches, and a vehicle hitting it enough to break plastic, you're going to have, beyond some scratches, you're not going to have these scratches lined up the same way all the way up and down the arm, number one. Number two, there's a point of impact. And as the vehicle is, if it hits your arm, as the vehicle is driving past you out of control, you're going to have your shoulder hitting the thing. There's going to be like a point of impact. And then how did it even hit the rest of your hand? If it hits your hand, then is that going to rip on some of the broken pieces that are still affixed to the car? So that you're going to have different jagged pieces all over, if this theory was even possible. But you don't have any bruises, and if there's no bruises, it's obvious it wasn't hitting the back. Karen's car wasn't hitting with the back of her vehicle onto John's body or arm whatsoever. This actually is exculpatory. There's nothing inculpatory about this. Really bizarre. What do you guys think about this? Could we have, I think there's some RNs here or nurses, NPs on the chat. Do you guys have any comments on this? Yeah, I don't know why the defense allowed him to make it sound like this is exactly what happened, but yeah. And where's the DNA then on the vehicle and on the all these 47 pieces of Karen's tail light? Yeah. And the other thing, yep, George Girl, where's the broken bones? Yeah, if it's enough to crack the plastic, you'd have some kind of fractures at a minimum. Yep, McRamblon, the plastic has to be first be broken before it can scratch flesh and the pattern of scratch along. So he never talks about that, how it broke up and how these shards of glass align with cutting his arm. Yet he declares it to be the case. Yeah, keep your chat clean. Thanks, Kokomo. Fierce like Frida, how many times did he do this? Does he show the outcomes? Also, we see this one. Little Miss Red Velvet, he's making it fit a story, not facts. He doesn't come across like an engineer at all. JM, you're saying you have to bend your arm more, Carl, to get the blue zones, 2 blue zones to match up. However, doing that brings the car close to the body, equals more bruising to the rest of the body and legs. And the bruisings wouldn't line up the same all the way up and down the arm, even if the polycarb was broken. And yeah, you'd have massive bruises and broken bones. Gwen Garnett, the expert in reasonable doubt. Bella's mom, John's bones were stronger than the 6-pound vehicle, moving 24 miles an hour. Carlos Delfino, he should be showing how the crash test dummy shatters the tail light. Yeah, he had no limitations on what he needed to do to solve this. And then he becomes a crash test dummy. Does anybody think this is science? This is physics at play here? That this is biomechanical engineering? Sandy, you're an RN. This never happened. Hidden metadata is the most insane thing I've ever seen. I just really think, I hope the defense has something to counter to this, because I don't think that under those snowy conditions, this car could go that fast. Also around a curve in the road. Michael L. Defense needs to have a certified Lexus rep to come in and testify as the safety features, any speed limitation was in reverse. Jennifer Rank, you're a nurse practitioner. This is impossible. Elbow is a hinge joint, shoulder, ball and socket. The arm would give way. There would be torso injuries. Yeah, there would be massive injuries here. I agree with you, folks. Suzanne, why didn't he do the experiment at the scene? Bring the new Lexus to 34 Fairview and film what you're claiming happened. Yeah, that'd be a good way to do it. Sandy, you're the nurse. Have you seen bodies that have gone up against cars and definitely have bruises and broken ribs and broken bones? Yeah, I mean, think about it. His ribs would be broken, fractures left and right. Yeah, what about the speed comparison? 2 miles an hour is comparable to 24. I mean, this is like so prejudicial. Really, you're going to do something that's that much of a vast difference? Yeah, there would be DNA on the vehicle. Come on, really? Katrina Raven says, I'm a nurse. I find this impossible to have hit John O'Keefe with no bruising or his shoulder not being seriously damaged. That's just common sense. I agree with you, nurses. It's just common sense. Yeah, Detective Olivia Benson. He started with an answer and then tried to make it fit the evidence. That's not scientific method. All right, I'm going to go ahead.
Location of the lacerations on Mr. O'Keefe's arm. Here's the post-contact scuffing on the taillight. Here's a picture of Miss Reed's vehicle on the right-hand side.
Yeah, because you just placed your arm up against there like that. What does this show? 2 miles an hour versus 24. You stick your arm in an exact angle to try to have something touch your bicep tricep area and your forearm. I mean, this is like quackery here.
So now I said, okay, that was me walking into the car. Let's have the car drive into me. I did this at
Oh, that would
very
be a
low
whole lot
speeds.
different.
And you'll see, and we'll show this from two different angles. That's me showing I'm doing test 2.
Wow. This is, how could anybody believe this is replicating what happened in John's arm? This is unbelievable. I mean, this is like more shock and awe than we had for Trooper Paul. We thought Trooper Paul was bad. This guy's, my gosh. Truth Seeker has to prove anything. Wow. Yeah. Yeah, we could have done a better backup experience than this guy. And this guy's got a PhD. Making big bucks doing this. In light, you're saying for John O'Keefe family members, you'd be pretty creeped out by him playing the victim. Who does this? Yeah, I mean, dressing up like him. What does that really matter? Wearing that shirt. What does a little bump from a 2 mile an hour get you?
This is from a camera that we have pointing down at it. This is the speed. You'll see it's only about a 2 mile an hour impact. But even a 2 mile an hour.
I'm telling you, if this makes it through the crazy court system in Massachusetts, any federal court that would look at this, they'd be like laughing at this crackpot theory.
Impact redirects me back and causes me to rotate and take a step.
Yes.
So this is biomechanical engineering at its finest, I guess, here, huh? Yeah, this is so strange. Queen of Hearts. Are they saying that she magically stopped on a dime after 75% pedal depression at the exact moment she hit John? I mean, he's not talking about that. See, they want to conveniently leave out the details, like where'd that car have stopped? Why don't you show where it would have ended up after those 10 seconds? But they're acting like it's dry pavement. And they're forgetting about the other vehicles. This guy has to talk about the other vehicles in the driveway, the low proximity to the mailbox. He's not doing any of this reconstruction there at 34 Fairview. They're ignoring everything that doesn't fit their little scenario. And they keep on changing their scenarios, right? Yeah. Mike, whose headphones, remember the written transcript magically doesn't have the judge saying that only medical doctors can opine on cause of injury, but the video and audio prove otherwise. All right, so there's a little break here for 5-6 minutes. Let's jump ahead.
And what slide is this? I think I just can't see it. What slide is this?
114.
Thank you.
You're welcome.
One moment, Dr. Welcher. When you were showing us this video, you walked to the side of the passenger side of the car, didn't you?
I did.
And why did you do that?
I was discussing with them what to do.
You were discussing with who what to do.
The driver.
In no way were you trying to imitate or give a demonstration of what you believed Mr. O'Keefe's movements to be.
Oh, no. This speed's just 2 miles an hour. I was having a discussion with the driver about what we needed to do to conduct the test.
So when you walked up to the passenger side, it wasn't to replicate a study or a movement or give an opinion.
No, that walking
simply-
had nothing to do with this case except for me instructing the driver what to do.
Thank you for that clarification.
Sorry about that.
No apology necessary. Could you go back to the beginning when you were explaining this so we can go through it?
So this is the dynamic test 2. So again, this is the view from behind.
Well, you know what? One of the reconstructionists they have at Aperture is from the Massachusetts State Police. He's a retired patrolman, and his resume is there on the website. So I should pull that at some point and show y'all. So that's the connection Aperture has with the state police there. They have a retiree working there, and he's the one that trained Trooper Paul, apparently. At least the timeline overlaps.
Just to avoid the confusion, I will start it here.
Which speed is the car traveling?
You can see it. About 2 miles an hour.
He's like walking away. He's not being thrown. So this whole thing is this staged performance.
Oh, okay. All right, so that's noted, Mr. Lysy.
So similar to the other test, this is the post-contact image of the transfers onto my arm. Actually, the yellow paint. You can
He's not talked about how the plastic polycarb pieces would have ripped into John's arm.
see from my hand is here. This is from the arm and forearm. Here's the paint transfer pattern.
And that slide number,
I'm
Dr.
sorry,
Welcher?
I'm terrible with that.
That's
Slide
okay.
116 now. That was 115.
Thank you.
Slide 116. What I've done is I've taken these yellow lines to show the
Anybody can tell this would be a massively smashed up arm and elbow. You wouldn't have all these perpendicular scratches, gouges that look like dog bite marks, as well as dog scratches. A big dog, a large dog, just like Chloe.
extension of the components on the rear of the exemplar Lexus. Then I've done this extension of those same components on the rear of Miss Reed's Lexus and shown how the approximate location of the fractures.
Probably we don't know how this thing's going to turn out. He's not done yet on the stand.
In the taillight match up with the approximate location of the contact of the arm onto the taillight.
Dr. Welcher, do you have any indication of how Mr. O'Keefe's arm was bent, what angle it was bent at?
Not exactly, but for these,
So then why are you doing it? You just admitted you don't know what angle his arm would have been at. You haven't even established that he's hit by a car with any amount of biomechanical testimony.
to be taillight shard fragments, they would need to be in the area of the taillight, but it could be further up. We know from the police photographs that
What's he even talking about? This doesn't even make any sense. He's just rambling. What's this mean?
Any indication of how Mr. O'Keefe's arm was bent, what angle it was bent at?
not exactly, but for these,
Again, not exactly. You're just wild guessing here, aren't you? That's all it is. Wild guessing. And the more he wild guesses, the more Hank Brennan falls for it and wants him up there testifying. They'll pay him whatever money he wants to be able to do this.
is to be taillight shard fragments, they would need to be in the area of the taillight, but it could be further up. We know from the police photographs that there was a damage to the rear body panel in the area I'm searching here.
Okay, once again, you're taking account that the police photographs did not have any tampering at the Sally port.
So it's possible his arm was a little higher up and the glass hit the rear of the Lexus and caused that damage.
In the bottom right,
Excuse me, your objection.
I will strike that last part about the glass.
Thank you.
the purpose
Well, what about moving to strike and instructing the jury to disregard?
of the circle is for what, Dr. Welcher?
To show, in this case, primarily the location of the lacerations up on the arm, the upper part of the arm, and that they match up with the locations of at least the one remaining shard in the rear taillight of Miss Reed's Lexus.
So that shard would produce a big scrape. It's not going to show like a dog bite type mark. I mean, this is bizarre that this guy thinks people would believe this.
Looking at the picture of the Lexus, bottom right middle, are there any marks on the Lexus itself that you took note?
It's a psyops. They got to dress him up like John and make this guy sound credible and do all this fifth grader type of stuff just to try to get the jury to fall for this and believe this absolute crazy nonsense.
of.
Yes, it's on the next slide.
Thank you.
Actually, it's 2 slides.
I mean, I'm just telling you, if I had this guy coming to me and tell me, hey, I want you to prosecute a case and here's what I got for evidence, I'd be going like, this is like not even credible. I couldn't even argue this with a straight face to a jury.
So there, again, this is the evidence marker. There was a horizontal scuff. We know Mr. O'Keefe had blue jean type pants on. There's a scuff in the area that would approximate.
You're not even showing all of his injuries on his arm. You're just showing a different angle. Look at that. You got part of the bed railing, side railing on there, blocking part of his arm. So it's unbelievable what kind of testimony you can get if you pay money for it.
They correspond to hip level for Mr. O'Keefe.
And next slide, please.
Yes, ma'am. 118.
Thank you.
Did you describe what you saw on the bottom right-hand corner photo as well?
I believe, yes, I did. That's the scuff that lines up with the approximate height of Mr. O'Keefe's right hip.
Oh, man.
So then I included previous image that you've seen, slide 119, with the reconstructed photograph of the rear.
Yeah. Where's the hoodie and the holes in the hoodie? Where's he showing the shards of glass without any DNA?
Taillight showing where some of the fragments are. You can see where those fragments are relative to the curvature of the taillight. They'd be in the area somewhat centered within the region of the 2 yellow lines.
Has he said anything that sounds like an engineering expert to y'all? In the last, how long have we been covering this on the injury to John's arm? None of this sounds scientific or physics based or medical based or biomechanical based.
On slide 119.
Is there anything about the photograph in the top right-hand corner that's important? If so, could you zoom in and show us?
So again, it's showing that this is when it's, I believe, in the Sally Port.
I mean, this is even worse than Burgess's testimony, in my opinion. What do you guys think? So this guy, let's say all his credentials are accurate. To have these credentials, academic credentials, and this experience, and this is what you come up with on a murder case?
At the police station, showing that scuff on the right rear body panel.
Apparently, Jennifer Rank, you're saying what credentials permit him to evaluate John O'Keefe's injuries. Apparently, just because has a PhD in biomedical, which a subset includes biomechanical. So anyway, he does have some other degrees related to engineering, but this doesn't come across any kind of engineering type study and testing. I mean, they could have used crash dummies and whatnot. None of this is even credible, because keep in mind, everything about this crime scene was just garbage in, and this guy's trying to make it perfection coming out. It's just all garbage in, garbage out. They got nothing. They got no case, and all this is just trash testimony.
Did you see any similar scuffs in the middle back of the car?
Sustained.
Did you see anything notable as far as damage to the middle back of this Lexus?
The middle,
Yes,
like back where the doors are?
with the middle of the back of the car.
So think of the smoke and mirrors. We don't see the side back part of this tail light at One Meadows. They conveniently don't show it there. And now they show it all broken out like that. It was never broken out like that when Karen was leaving One Meadows. Get real, folks.
Did you see any similar damage to the middle? or
There
the
were
left?
scuff marks that ran along the bumper.
Okay, continue, please.
So this is just showing his jacket he was wearing, that the puncture marks coincide to the marks on his arm.
Puncture marks corresponding. Okay. Punctured by fragments of glass that don't have any DNA, and they found no polycarb on his arm or stuck in his arm.
This is from the autopsy report. A couple things it notes: a 0.5 centimeter abrasion on his right lateral knee. He's got a laceration on his right eyelid. That corresponds to the height of that thin rear wind wing on the back of the Lexus.
I'm going to object.
Sustained.
Thank you.
How tall was Mr. O'Keefe?
73 inches wind wing, right eyelid, on his right lateral knee. He's got a laceration on his right eyelid. That corresponds to the height of that thin rear.
Oh, so all you have is a little laceration in your right eye. If you got hit by that visor, that spoiler thing on the back of the window, above the back of the window there, that's pretty bizarre. No bruising, just a laceration. Granted, his eye was bruised, but that's more like from a punch. He doesn't talk about that here as of yet.
Wind wing
But he gets to
on the
his
back
fault
of the
later.
Lexus.
I'm going to object.
Sustained.
Thank you.
How tall was Mr. O'Keefe?
73 inches tall, 6'1".
And how high was that wing from the ground on the back of the Lexus?
It was about it's about 5 feet 11 inches, maybe 5 feet 10 and a half.
Thank you.
You're welcome.
This is not even scientific or
Did you
engineering.
notice anything about Mr. O'Keefe's right knee?
I wouldn't even
noticed
call it
there was
high
a
school.
0.5 centimeter abrasion on the right lateral knee.
Did you note how high from his foot that bruise was on his knee?
We don't know the exact length of his knee. The abrasion appears to be right here at knee level. If you go back and look at where my knee is, that would be at the approximate level of the bumper.
Could you focus in on the bumper to show it relative to the height of your knee?
Sure. Oops.
This is so stupid. The height of your knee. What if John is longer legged and shorter waisted
So
than
my
this
knee is
guy?
approximately right here. This
Unbelievable.
is where the bumper is.
You could have gotten some kind of crash dummy exact same dimensions as John O'Keefe, but this guy becomes a crash dummy.
So the side of Mr. O'Keefe's knee will be in this general area.
Okay, thank you.
You're welcome.
Sir, do you have an opinion to a reasonable degree of engineering certainty about the lacerations on Mr. O'Keefe's right arm and forearm regarding its orientation relative to the broken taillight on the defendant's?
He hasn't even said how the taillight would have been broken. And what about any bruising or broken bones? This is so.
Lexus.
Yes. Your Honor, may I read my report, my opinion?
Okay.
The location
Why don't you just know this off the top of your head? You've had multiple days even there waiting for this testimony to occur. You should be able to know this off the top of your head.
and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right taillight of the Reed 2021 Lexus LX 570.
You haven't even explained how it happened. You can't even explain how it happened. That's a declaration. You have not explained how it happened, doctor. Can you imagine being convicted with this kind of testimony,
After considering these three different subjects that we discussed, the text stream data, analyzing the touching between the defendant's Lexus and Mr. O'Keefe's car, and then your demonstrations regarding the injury to Mr. O'Keefe's right arm, did you consider further evidence in reaching any conclusions as an accident reconstructionist and a biomechanical engineer?
Yes, I did.
Could you turn us to slide 124, please?
So this is some of the location of the physical evidence. Red plastic, clear plastic. There, his point of rest was indicated to be 7 feet off the roadway. There was a sneaker that was found near the curb. There were various fragments of taillight found in the snow on the morning of the incident, as to the afternoon of the incident.
Could you zoom in on those photos so that we can see the dates?
The date?
Yes.
Oh, sure. So January 29th at 5:46 p.m. This one's at 5:52. One's at 5:59. This one down here is at 5:46. So there were various fragments of the taillight that were ultimately pieced back together and determined to be from Miss Reed's right rear taillight.
yeah, he's not talking about the fact that they couldn't find anything out there. It took them days to find all this evidence, supposed evidence.
Additional evidence was found.
Unbelievable.
This is taken on the afternoon of the accident, again, around 5:50 p.m.
Could you zoom in, please, for us?
Sure. So what you see here is was later identified as Mr. O'Keefe's right shoe.
And this slide number, Dr. Welcher?
Yes, ma'am, 127.
Could you show us the time and date, please?
January 29th at 5:50 p.m. So a series of photographs. Again, you can see on the right-hand photograph that this is the roadway. This is the curb. The grass will be up towards the top of the right image on slide 127. The shoe is found, up against, in the roadway, up against the edge of the curb. Baseball hat.
This guy's proven nothing on all this bodily injury stuff. Nothing, absolutely nothing.
Again, acquired a same baseball hat. Baseball hat was also found in the snow. You can see.
I want you, before you move ahead, the baseball hat, could you give us a
What?
close-up view and also the date and time?
So that's where it's buried in the snow. These were taken on February 3rd. I'm not sure what time it was.
Multiple days later, opportunities for planting.
There was also red liquid identified, I believe they indicated to be blood, in the snow as well.
And could you give it,
So I'm going to sustain that objection and strike the last part.
I
We
understand.
don't need to come to side, right?
Just describe the color of what you saw rather than what it was.
There was red coloration in the snow.
And could you give us that date if it's different than February 3rd?
I thought that was February 3rd as well.
Is there a date on the photograph to the left?
That's what the jury heard. Other than what I showed you
don't
at the
see one.
beginning tonight, jury's been seeing all this.
Do you know if those photos were taken by the Canton Police Department?
System.
Do you know when exactly those photos were taken?
I don't, except I have them dated as February 3rd. But I think that may just be the baseball hat photos.
Okay, can you continue?
Then we have photos of a broken glass.
Okay, he's just testifying. This is what this is. This is what that is. What's that got to do with his expert opinion?
Surrounded by red marks in the snow.
Continue, please.
This, by the way, is the flagpole.
And that slide number, please, Dr.
Yes, ma'am, 129.
Thank you.
Slide 130.
This
Can
is
you
really
enlarge that and
interesting.
explain to us what that is?
Sure. So at the bottom, it indicates where it's from. So this was from a presentation I gave looking at pedestrian injury biomechanics back in 2005.
So we're looking at something from that he presented at a conference 21 years ago or 20 years ago. Look at he has Aperture there advertising.
And what it's showing is where various, or what are the most common injuries in pedestrian impacts. So what it shows is head injuries are the most common injury in pedestrian impacts. So on the right-hand side, it's all injuries. You can see of all the individual study, the highest prevalence or highest or most common injury was head injuries. In those that sustained severe life-threatening injuries, again, the highest was also head injuries. So head injuries are very commonly associated with pedestrian impacts.
So
This
let me
is
back up on that.
So head injuries are very commonly with head.
So he's looking at percentages of people of 2,582 persons, and they're showing figures in percent. So he's using statistical data to back up this quackery and say that, see, John must have been hit by a vehicle too, because he had his worst injuries in the head and not in the rest of his body, and like these other places have. So it's so he's trying to use statistics basically to try to show Karen Reed is guilty. I mean, this is like unheard of. You don't see this in criminal law settings at all. It's just so bizarre. I don't know why defense isn't objecting to this. I sure would be if this was my case in Texas.
Head injuries. In those that sustained severe
This guy's out of control.
life-threatening injuries, again, the highest was also head injuries. So head injuries are very commonly associated with pedestrian impacts.
What does this guy talk to that's objective when he's trying to link Karen with the bodily injury of John O'Keefe? There's nothing objective he's talking about. It's all just wild speculation, and it doesn't even pass common sense or physics.
This is anatomical drawings just to help you understand the anatomy. The middle section here is from Mr. O'Keefe's autopsy report. The lower right diagram, the green line represents the fracture lines, predominantly here, at least in the base of the skull. So in the biomechanical and forensics just means the legal related scientific industry, there's something called hat brim line or hat line analysis. And what it is it's looking at where the hat line, you can imagine, is where the brim of a hat would be. And what it is, it's literature that's looking at where head injuries from falls commonly occur.
I'll strike, I'm going to strike. Strike. Yes, yes. So that was slide 131.
No, that was 132. I moved it because you said, let's take it off the screen.
So jurors, when I strike something, that means don't pay any attention.
Continue, Dr. Welcher.
So Your Honor, I need to go past that slide.
Okay, go ahead, go past it.
This is the next slide.
Okay, if you can continue.
Sure. So I provided peer-reviewed scientific literature that looked at a metric where they were publishing research trying to delineate falls versus blows or assaults. And so this metric is in that scientific literature. They looked at a total of 400 different events, 235 falls, 165 assaults. And so you can see where it says mandible. So mandible is your lower jaw.
So now he's comparing injuries on some study long ago based on falls versus assaults.
Can you enlarge that a little bit, please?
Your Honor, pardon the interruption. I'm moving to strike.
Yeah, let's take that slide down. I'm going to see you at sidebar, please.
So he's trying to do statistics again. This is like reversible error. This is not anything like I've ever seen civil trials in America. This is really bizarre. But this whole trial has been bizarre. It's all a persecution. It's all a star chamber. Like I've said before, when they have these long sidebars, like this morning when they had 90 minutes, where we're just waiting in the wings, not knowing what's going on, all that should have been for the public viewing. But all this stuff is done in secrecy there in this courtroom where we can't see what's going on. If the jury's not there, we should be listening to it. G.S. Jackson, 72. I have 5 years of engineering. I believe this man would have washed out as a mechanical engineering major or medical engineering major at my school. His experiments are shocking. Tell me about it. That's what I'm saying. I just can't believe this stuff passes for testimony and trial of law, criminal trial law at that. Manny V, if John was holding the cartel glass when he got hit by the SUV, how come the hand and his fingers do not have any cuts? Yeah, none of this adds up. It's just all quackery. All right, let's jump ahead here. We're from 6:30 to 6:38. There's lots of huddling. They're conferring with the witness here, but the jury's not there. See,
Thank you.
just don't know what's going on there. I guess they had some kind of glitch with maybe the slides didn't add up properly. They haven't started yet with the jury, so let's go back. Here's a jury coming in.
Please be seated, court is in session.
Dr. Welcher, if you could return to slide 132. Actually, 133, Dr. Welcher.
Is that me or? $132 or 133?
133, please. The next one after that.
So we did skip over 132.
We skipped over that one as well. Keep going. There we go. If you can enlarge that just a little bit for us.
Sure.
Now, you mentioned that there was studies that talked about guiding the difference between potential injuries.
Correct.
Okay, explain that.
Sure.
Yes,
So
could you
there's
now look at
again,
that?
3 papers and someone's dissertation on this issue. They are creating a analysis methodology to differentiate whether the nature and pattern of injuries are more consistent with a fall or more consistent with an assault, or they're calling it blows.
Okay, could you walk us through what this chart means?
Sure. So this is their flow chart in terms of their assessment. So it starts at the very top. You can see they analyze a total of 400 events, 235 falls, 165 blows or assaults. So what you do is you ask yourself on the first set of arrows, you look at the mandible, the jaw. And MRS, as you can see at the bottom down here, refers to a simple fracture or multiple fractures. A is no fracture. Mr. O'Keefe has no mandible fracture. So that means we go down this row. It then looks at all facial fractures. So these are the bones that constitute the face. So if you have a facial fracture, you go to your left. If you have no facial fracture, you go to the right. So if you have some event, no mandible fracture, no facial fracture, what they've indicated that is predominantly associated with falls and not assaults.
Thank you.
You're welcome.
In addition, did you do any further study on the force of a person falling back and landing on their head?
Oops, I did.
Could you
So what I did was I did what are called drop tests. I took an anthropomorphic test device, ATD, which is just a fancy name for a crash test dummy, and dropped it backwards onto a hard surface to look at what happens if you were to say fall backwards and hit your head onto a hard surface.
A
So-
hard surface. They keep on saying hard
On
surface.
this particular photograph,
He's talking just like Hank Brennan. It's not a hard surface. It's grassy area there. Are you saying John was landed on asphalt? Which is it?
of Mr. O'Keefe in the upper left, there's noted to be abrasions above the fracture line in the area. You can't see that at all. You can see. Noted to be abrasions right here. Your Honor, I brought a hat. That was the one I used in my testing. May I put it on and demonstrate something?
Mr. Lessie,
If you would like a sidebar, or I can.
are you objecting?
I am objecting.
That's sustained. No, you can't.
Okay, so I will show you the dummy test I did. Watch when the shoulders hit the ground, then the head hits the ground. It creates kind of an arc path that will drag and slide objects up the head. So if you have something such as a baseball hat, it'll cause it to drag across the scalp, dragging it up to a similar location to where these abrasions are. So here's the testing. Again, this is a crash test dummies you see on television. This is myself. You're giving me similar instructions, telling them what we're going to do. I said, and watch.
Oh, there you go.
Shoulders come in,
Wow.
then the head contacts the ground. What you see is if you fall backwards and land on a very hard surface or hard surface, you will get extremely high loads on the head.
A drunk person falling back on some grass with some snow on top of it. Really? That's the same as falling on concrete?
If you compare that to data in the
Highly misleading, prejudicial. It's not realistic.
sign,
I'm sorry to interrupt.
Yeah.
Can you pause that, please explain what the chart is before you explain?
oh, sure. This chart up here,
Nope, on the next page.
right,
You can enlarge it, tell us what it is before you get into the details.
absolutely. So this is actually kind of a famous study that was published, one of the first studies looking at head fracture or skull fracture tolerances. So what you see, the portion at the back of your skull is called the occiput bone. So that bone, if you put your hand in the back of your head, is your occiput. So we're looking at occiput impacts. And what you can see is that when they took cadaver skulls and dropped them from as low as 40 inches onto a hard surface, they were getting
A hard surface. That's such a broad term. So for you to just use that broad term and use again this kind of old data, and you're talking about cadavers. Cadavers aren't the same as a live human being.
linear fractures. And you can see even at 40 inches, there is called a stellate fracture. Stellate means star-like. You get a fracture that goes out like a star. So even at a 40-inch drop height, you have sufficient force when landing on a hard surface
Yeah, I'm sure that's on concrete.
to cause skull fracture and a level 3 type skull fracture. So Mr. O'Keefe, again, is 73 inches tall. His occiput is about 4.6
This is so cringy and embarrassing.
inches
isn't it?
down from the top of his skull. That means it would fall a total of about 60 or 73 minus 5 would be 68. So just under 6 feet. So 72, 4 inches under. So 5 foot, 8 inches is the fall height. What is data showing that even at a fall height as low as 40 inches onto a hard surface, you can get fairly severe skull fractures.
Thank you. Dr. Welcher, regarding your third part of your analysis, did you come to a conclusion to
So if you can't prove a connection to Karen's car hitting John, and John could have just slipped and fell and landed on his back, getting his foot caught on something going to the house, then
reasonably agree
is that easy to die?
engineering uncertainty whether or not the defendant's Lexus collided with Mr. John O'Keefe on the evening of January 29th, 2022, around 12:32 a.m.
Yes.
Before you give me your opinion, I'd like you to share with the jury what that opinion is based on.
Sure. So it's based on the 130 slides you've seen, based on
Based on 130 slides. Yeah, okay. Leaning there on his arm and elbow.
my personal inspection of the Lexus, the correlation of the text stream data with the infotainment data, as well as Mr. O'Keefe's cell phone data. It's looking at, I guess, where the taillight wasn't broken. It's looking at the physical evidence at the scene in terms of taillight fragments, glass fragments, red color in the snow. We have the cell phone data, the location and position of the arm lacerations, the air temperature at the time indicative of sufficient to freeze, the location of the fracture on the back of his head relative to the scientific literature, my testing of forces available falling onto a hard surface, published science on the fracture forces associated with falls. And I'm sorry, I'm reading from my report.
rather than
Yeah, he has to read from a report. He can't testify based on firsthand knowledge about it. Unbelievable.
I'm reading from my report.
Can you answer without reading from your report?
That's what happens, folks. People testify as to what they know. You don't have cops going up there just admitting police reports. They have to testify as to what they did, what happened. And same with this guy. He needs to describe firsthand what he's concluding about this case as an expert, not just reading off some scripted summation that he had.
Probably it's more complete if I read my report.
Huh.
Any objection, Mr. Leslie?
I do on this question, Your Honor,
You don't do that and just have people reading off stuff that they wrote. That's not how we do trials in America.
reading from a report
Welcher, let me ask you again. Based on your analysis, data available, reviews, study, based on the fact that you are an accident reconstructionist and a biomedical engineer, have you reached an opinion to a reasonable degree of engineering certainty whether the defendant's Lexus struck Mr. John O'Keefe on January 29, 2022, around 12:32 a.m.?
Yes.
And could you share the bases of your opinion before I ask you your ultimate opinion?
Sure. So again, you've seen my slide presentation. I've inspected the Lexus. I've looked at where it wasn't damaged. I've inspected the taillight. I got an exemplar Lexus. I ran lower speed contacts to verify that the injury pattern and location on the arm is consistent with the height and orientation of the taillight.
No, it's not.
I
That's
have
an
looked-
absolute garbage to sit there and say that his injuries came from that vehicle.
Looked at fracture tolerance data
Wow.
for falling backwards onto hard
Karen's life is on the line, and this is the garbage you're going to present to a jury. It's absolutely disgusting.
surfaces. I've looked at the metrics of where his
You haven't looked at anything from a engineering standpoint.
injuries were and what injuries he didn't sustain. I've looked at the cell phone data, and then I've looked at Miss Reed's interviews as well.
There you go.
Based on all the evidence you consider,
Look at that confirmation bias. He's looking at interviews to try to formulate everything. He's trying to basically take the role of proctor here.
could you share with the jury what your opinion is to a reasonable degree of engineering certainty about whether the defendant's Lexus struck Mr. O'Keefe on January 29, 2022, around 12:32 a.m.?
Objection, Your Honor.
Hold on.
I can answer. Yes.
29,
What?
2000. The jury, what you
And then I've looked at Miss Reed's interviews as well.
Based on all the evidence you considered, could you share with the jury what your opinion is to a reasonable degree of engineering
It's not evidence.
certainty about whether the defendant's Lexus struck Mr. O'Keefe on January 29, 2022, around 12:32 a.m.?
Objection, Your Honor.
Reasonable degree of certainty, whether it's struck. ARCCA couldn't even do that. They just said it could be consistent or not consistent with the striking of a vehicle on John O'Keefe's body. So this is way more than what ARCCA was allowed to in trial one.
I can answer. Yes, based on the totality of the evidence, DNA, everything I've talked about, that is consistent with that happening with a reasonable degree of scientific certainty. That is what happened.
Objection, move to strike, Your
So
Honor.
I'm gonna strike that. I wanna see counsel's have up just.
Yep. Yep. Just go ahead, dump truck all this opinion testimony in. You don't have any evidence to back it up. You don't have any sound engineering studies to prove anything. All right. So they're going to have a sidebar. And then what happens is Dr. Welcher and the jury are dismissed. And then we have an argument of counsel Leslie here at 7 o'clock or 7 hours into it.
Dr. Welcher.
Dr. Welcher can step down. I know he has to come back and have his
So just
equipment.
leave everything here.
And then you'll come back in 5 minutes.
Roger.
All right. Yes, please. All right, so Mr. Leslie, I will hear you as to your objection.
Thank you, Your Honor. Would you like me to go to the podium or stand?
Right there's fine, and let's try and wrap it, this all up by 4 because I've already heard you at sidebar. That means both of you I'll hear from within the next 5 minutes. Go ahead, Mr. Lessie.
Thank you, Your Honor. The point number one is the question of whether, based on a reasonable degree of scientific or engineering certainty, he has an opinion whether a collision occurred. I'm going to give a dramatic and accurate example that happens in courts all the time equivalent. So, by analogy, if the issue is whether or not a defendant has stabbed an individual and caused a certain event, that is the ultimate question for the jury. That question
It's invading the province of jury, and he's been doing it through much of his testimony.
is never permissible in a trial. By analogy, this is the exact analogous situation. The question of whether there was a collision is the ultimate question for the jury. That is why we are having this trial. The defense strongly asserts there was no collision, and there is substantial evidence to that. We are going to cross-examine Dr. Welcher. We are going to put in our own strong case to.
I've never seen like this. I mean, this is like astounding. The stuff you see day in, day out. It's just an absolute sham kangaroo court.
Demonstrate no collision occurred. That's no surprise. It was in our opening statement. This witness cannot, by precedent for years, opine on the ultimate question that is going to the jury. I accept, subject to evidentiary issues, the two questions that a biomechanist always answers in these situations. Is the damage to the vehicle consistent with a pedestrian hitting the vehicle? And is
Judge knows that. That's all she allowed ARCCA to talk about in trial one.
injuries to the individual consistent with being hit by a motor vehicle? Those are the questions that are permissible, not the collision question. It is resoundingly improper in this trial, in any trial where that is the ultimate conclusion for the jury. Yes, an expert can offer opinions, but every expert is bounded by the extent of their opinion, and that opinion on whether there was a collision would invade the province of the jury and the whole purpose why we are here, Your Honor. Thank you.
All right, Mr. Brennan.
So what Mr. Lisi is arguing is that in their opening statement, they
Okay, Mr. Lisi, you know, his name is Mr. Leslie. So how dare you continually throughout 6 weeks of trial continually mispronounce his name? That's what a kind of lawyer this guy is, folks. He's representing the Commonwealth. I don't know what to say. And no judge would allow an attorney, a real judge would allow an attorney to continually in front of a jury mispronounce the opposing counsel's name. That's how slimy and sleazy this whole process is. Absolutely disgusting.
The province of the jury, because they must have asserted vehemently over and over again there was no collision, over and over and over again. And he just told you that when his expert takes a stand, they'll have abundant evidence that there was no collision. This case is about the collision, but that is not the ultimate issue. The ultimate issue.
He's just talking past what defense just raised. He's just completely talking past it. It's the fact that he gave the opinion numerous different ways that a collision had occurred. He didn't say it was consistent with or not consistent with the evidence, consistent with the theory of the government or not. He's actually talking about the ultimate issue. So now he's saying this is not the ultimate issue.
Is manslaughter or mens rea for second-degree murder, not collision. They don't get to define the prosecution's case. They do not get to define or limit the prosecution's opinions. They have no case law. They have no study. They have.
You just had this expert multiple different ways say that ultimately, yes, in my professional opinion, it happened. And he just made it sound like it happened without even asking that prelude to it, which is like with your reasonable scientific certainty or reasonable engineering certainty. what does all that even mean to the jury? He hasn't explained that to the jury. And but what he's doing here is he's just completely putting a spin on what the defense has raised, which is completely what the defense should have been raising multiple times throughout this process. I think that's what I would do if I was representing this case here in Texas anyway.
Have no jurisdiction or jurisprudence to say what we are limited to. He's entitled to an opinion. His opinion is not limited to whether or not the defendant struck Mr. O'Keefe. That evidence is obvious. It's
Wow, this is such garbage, guys.
not whether or not there's damage to the car or Lexus. That evidence is obvious. He also is an enormous.
Oh, because it's obvious he can testify to that. Okay, how come Lally didn't allow ARCCA to testify to this in the first trial? And Judge, you know darn right this is what happened. It's an absolute disgrace justice system. There is no justice here. It's all about convict Karen Reed at any cost, at any laws. You have to follow any constitutional laws. It doesn't matter. And why do you have to do that? If she's so guilty, why do you have to resort to all this scummy, evil process?
As part of a biomedical engineer and an accident reconstructionist. He studied the text stream data. They didn't, he did.
This has nothing to do with what Alessi just objected to again. Alessi objected to the fact that he's stating as a fact, this is what happened. He's not saying stuff is consistent. His opinion of the evidence is consistent that supports the theory that a vehicle strike is what caused John O'Keefe's injuries. It's just all just, I don't know if you guys see what I see, but he's just putting all spin. It's all slick spinnery.
And he's entitled to give an opinion. The text stream data based on fact and science and data.
He can give an opinion as to ultimate conclusion that Karen Reed is guilty of hitting him with the car. No, that's not possible. That doesn't happen in American courts, and you know it.
Tells us when, if you put it together with other evidence, and where, when you contribute it with other evidence, this collision actually occurred. We don't have to put.
You know, a judge would just shut, in a real court of law in America, a judge would say, sit down. She would cut this off. She would cut it off. As soon as you start saying the ultimate opinion on stuff, a judge would cut it off. You wouldn't even have to say anything about it because the judge knows that it's reversible error. The reason they're allowing this now is because they found an expert that can say this, and without any credibility whatsoever, he'll still say this. And now ARCCA, they'll probably try to block ARCCA from being able to say the same thing, in which I said all along, ARCCA should be able to say there's no way John O'Keefe's injuries have anything to do with a vehicle strike at all. Not just consistent or not consistent with, but say absolutely no way is there any possibility to make it more than just a 51-49% ratio.
Play peekaboo and close our eyes to the reality of the fact that the evidence supports the conclusion to a reasonable degree of engineering certainty that the defendant struck Mr. O'Keefe with her Lexus in front of Fairview Road. I am not interjecting the defendant. I always refer to her car, so it is sanitized, her Lexus. I've been careful about that. I don't have to, but I'm very careful about it. He is relying on the text stream data, the physical evidence, his independent studies. He is allowed to offer an opinion about whether the injuries are consistent with the damage to the car, or whether the damage to the car is
He's done more than that earlier. It just wasn't objected to every time they could have and should have.
consistent with the injury to Mr. O'Keefe. And he's also allowed to answer, in his opinion, the issue of a collision, putting aside the fact that that was emphasized and repeated in the opening statement, and it's going to happen again when other people testify. It's not our fault that ARCCA didn't testify or look into the text stream data, or they don't have an expert for it.
You know, if a gun's used in a crime or something and there's somebody prosecuted for a murder using a weapon, do you ever see a cop testify, in my opinion, this is the gun that killed the defendant? No, they always have to prove it and let the jury come to that conclusion through the location of the gun, the DNA testing, the shell casings, the ballistic matches, all that kind of stuff is what they have to prove it by. They just don't get up there and say, oh yeah, this guy, we know for a fact that that the defendant killed the victim. You have to prove it. You can't make those conclusory opinions that invade the province of the jury. The jury's responsibility is to find the truth based on the evidence presented, not this guy act as the judge instructing him to find him guilty in essence.
It doesn't belittle or limit that evidence. We expect to ask Dr. Welcher, does he have an opinion to a reasonable degree of engineering certainty whether the defendant's Lexus collided with Mr. O'Keefe on January 29, 2022?
No, you can't. You could say, is it consistent with the injuries of the arm, consistent with what you've seen? You cannot say reasonable degree of certainty. Certainty makes it sound like you're certain that she actually did it.
Around 12:32 a.m.
He knows
That
this.
is one of the opinions we're going to ask him. Nothing to do with the ultimate opinion of guilt or innocence, or whether it's manslaughter.
Oh,
whether it's
sure it
mens
is.
rea or
Sure it
something.
is. You need to know it.
And what was your second? You said that's one of the opinions you're going to ask him. What else are you
I
looking
will
at?
also ask him about the consistent with, whether the injuries are consistent with.
With what?
I'm going to ask him after this part about the difference
It's
between
mistrial
a clip or a
galore.
side swipe as opposed to a full-on injury.
All of you are a disgrace and embarrassment. I'm ashamed as an American. I'm ashamed
Pedestrian collision from a front or back.
as a lawyer. I'm ashamed as someone that's sworn to uphold constitutional rights of folks. This is absolute disgrace. I don't have enough words to describe what this is. It's not even healthy to watch this trial if you know anything about the law.
Slides to emphasize that point. And so there'll be an opinion regarding that as well.
And you,
Consistency with a side swipe or a clip.
okay, so this is not the end of Dr. Welcher's.
I can't even stand to listen to this guy's voice anymore, folks. I mean, this has been going on for weeks now. This is this bad.
testimony. He's just moving on to another area.
It's close, but it's not the end.
Okay. Go ahead. Yeah.
Your Honor, here's a case. Attorney Brennan said, go to case, well, here it is. Commonwealth v. Coleman, 366 Mass 705. And it stands for the proposition exactly that I articulated. I won't repeat it. Secondly, Your Honor, we practice what we preach. I have the ARCCA report right in front of me. And I have the report.
Is that a new one or is that
This is the new one.
okay.
It's also, the old one is the same. So I can either one.
And the judge knows it. The judge cuts him off. It's just this absolute cesspool of slime. Seeing this every day.
Mr. Brennan incorrectly said what our experts are going to do. I don't know why he did that because he has these in writing. Neither Dr. Wolf or Dr. Rentschler talk about a collision or conclusion. It's consistency. It's those two questions I said at sidebar. And for reference, Your Honor, for the most recent is page 15. There is no.
I don't have that report, so I'd like a copy of that
I will give
report.
Your Honor, a copy, and I also, Your Honor, refer Your Honor to ARCCA's existing report, which I'm going to do from memory. I think is February of 2024 that was done for the U.S. Department of Justice and FBI, where they basically said and gave opinions on those two items I spoke to you at sidebar. So Attorney Brennan is incorrect when he says what our experts are going to say or not. We've already committed in writing to what they're going to say. We're consistent. We practice what we preach.
All right. So we will discuss this tomorrow before we start. I'll tell you my ruling tomorrow before we start. I need to go back and see what exactly came in to evidence today. All right. So I'll see you in the morning.
All right.
Yeah, you don't know. You've been sitting there watching the trial all day. You don't know what happened. Unbelievable, guys. This is so unbelievable. All right, thanks to somebody's alerting us to. Let's take down this kangaroo court. What I'm going to do now is show you something on Welcher where he's excluded as a witness. So somebody shoot shot us this tonight, so I'm going to show this here. No. This is a civil case. It's not criminal, but check this out here. Motion to exclude. This is a plaintiff's. This is orders on motions in limine. So this is Carol Cavey versus Christopher Simons. So this is from June 1st of 2022. So the plaintiff's motion to exclude the defendant's testimony, Judson Welcher, allowed. So that was granted to exclude him. Said first, Welcher's analysis of how the force of this accident affected plaintiff's anatomy relies on the delta V calculated by Curie Alvino to determine the force of the collision. For the reasons set forth below, Alvino's calculation of the delta V is unreliable, therefore rendering the whole underpinning of Welcher's analysis unreliable. Second, the relevance of Welcher's opinion is questionable because his analysis is not sufficiently tied to the facts of this accident. And they cite a Massachusetts 97 case that says a consideration of relevancy is whether the expert testimony is offered sufficiently tied to the facts of the case so it will aid their jury in resolving the matter. And it goes on to cite another 2005 case, Commonwealth versus Patterson, that says expert testimony is admissible if, in addition to the reliability of the theory and process in general, that process is reliable when applied to a specific issue about which the expert is proposing to testify. And then it goes on to say, while Welcher cites one study involving a person of similar age with similar pre-existing conditions to the plaintiff, although he does not identify the size of the test individual, he does not identify maybe he was the test individual. Like in this case, the test dummy, he does not identify the characteristics of any other individuals involved in the nearly 1,000 tests upon which he relies. In fact, Welcher's method of analyzing the impact of an accident on a particular individual by relying on how similar impacts have affected other individuals has been deemed unreliable by the Society of Automotive Engineers because of variations in individuals' tolerance for physical force. Similarly, there is no indication where any of the studies involved in vehicles of the same size or weight of those involved in this accident. And it says compare the case of Silver versus McQuinn, another Massachusetts appellate case from 2011. And it says finally, one of Welcher's opinions, no structural damage or failure of the cervical disc occurs. It's based on cadaver testing, which is an unreliable method for analyzing how force affects live human beings. So there you go. There you go. This should have been objected to. Thank you, whoever sent that. Let's see here. Stand by. Well, I guess I don't know if you sent it or you just you mentioned the name, and my wife found the case, so thank you. So this part here, one of Welcher's opinions is based on cadaver testing, is an unreliable method for analyzing how force affects live human beings. Well, guess what? He just testified to that. He used another cadaver test on falls. Wow, this is a civil case. This is not life and death. You know, this has to do with money damages and civil lawsuits like this. Here you're talking about somebody's life on the line. You're telling me he doesn't know that this is unreliable to use cadaver testing? This is the PhD that we got here in this case, and Karen's life is on the line, and he's already been banned from testifying. Of course he knows he's banned from testifying. Of course he's seen this. So let me also go to the motion. Stand by, let me find it here. stop this screen. Okay, here's the plaintiff's motion. Yeah, this is filed May 6th, e-filed 2022, KV and KV plaintiffs versus Simmons, a service company, and a protective insurance company. The defendants recently disclosed Welcher, a biomechanical engineer who's expected to testify at trial, that the force the plaintiff experienced in the collision could not have caused the injuries she sustained. And they argued that Welcher's opinions are not scientific or not reliable and should be excluded on following grounds. He basically used somebody else's calculations of another defense expert. They said his opinions regarding the force of the collision, the effect on the plaintiff's body, are not reliable, not supported by facts and evidence. And as a biomechanical engineer, is not qualified to render opinions about the cause of plaintiff's medical injury. So why is he allowed to do that here in this court of Canoni? Okay, here's the first one. They said his opinions are not must be excluded because they're not reliable, not supported by facts and evidence. So he relied on Alvino, but Alvino failed to accurately document the vehicle's position during the collision. Where has he done that here in this case? It says, despite this evidence, Welcher's opinions assume the defendant's vehicle is aligned with the plaintiff's when it struck its rear end. The assumption is not accurate. The positioning of the vehicle impacts dictates the direction of movement of plaintiff's body as a result of the collision. He cannot give reliable opinions about the effect of the force of the collision on the plaintiff, and when he has an incorrect understanding of the direction of that force and position of the vehicles when the incident occurred. Okay, here it says studies and literature cited by Welcher are inapplicable to the case at bar. Under Massachusetts law, a biomechanical engineer will be precluded from testifying at trial unless he can show he's conducted testing or examined studies involving the same vehicles or the same individuals under the same circumstances as the subject accident. So even a civil case, you have to have this tied into the same vehicles and the same individuals as well. So he cannot describe exactly where John O'Keefe was, where the vehicle struck him at. We haven't heard any of that. We haven't heard anything about the polycarb glass, plastic pieces in the back, how they would have broke apart and to actually cause those type of injuries. There's no testing of that. In this case, Welcher admits he did not examine the collision or conduct any testing. His opinions are based entirely on references, studies, and literature were not performed under similar circumstances to the November 2nd, 2016 incident are not relevant to this action. All the studies involve testing on cadavers or live human volunteers who are aware of a pending test collision. Welcher's alleged research asks this court to accept that no person could suffer an injury to a rear-end collision at less than 10 miles per hour. This opinion goes contrary to everyday experience and common sense. And they cite this Washington court that says you cannot use cadavers. It says here, Welcher's own literature acknowledges that cadaver testing is not a reliable way to study the impacts of rear-end collisions on the human body. Welcher even wrote that responses obtained from rear-end studies employing surrogates, such as cadaver dummy testing, remain of questionable significance. Cadavers clearly lack muscular input, which is likely an important contributor to occupant kinematics at a low speed rear impact. He opined that cadaver testing is not be capable of accurately simulating live human responses. And yet he's doing it in this case. It says here, Welcher's methodology for determining the alleged effect of the collision of the force on the plaintiff's anatomy is not reliable. In his attempt to explain the effects of collision force on the plaintiff's anatomy, Welcher compares the alleged forces generated by the collision to acceleration forces that test subjects' experience doing everyday activities like jumping, skipping rope, and climbing on monkey bars. The relevant scientific community has expressly rejected this methodology and the idea that someone's personal tolerance to an injury can be determined by comparing them to studies measuring forces experienced by other people performing everyday activities. In 2011, the Society of Automotive Engineers, SAE, Human Biomechanics Committee published an authoritative guideline containing data relating to the tolerance of human tissues and materials to forces to be used by automotive engineers when designing automobiles. The report states that a comprehensive discussion of the factors involved in the determination of human tolerance levels is beyond the scope of this report. Indeed, such specifications are beyond the state of the art in biomechanics, except perhaps a few academic situations. There are several difficulties which prevent a readily establishment of human tolerance levels. Large difference exists in the tolerances of different individuals. It is not unusual for the bone fracture test on a sample of adult cadavers. Well, that's what he did tonight. We saw from his testimony earlier today to show a 3-to-1 load variation. Presumably, the variation of at least this magnitude exists in the living population. Finally, most tolerance levels are sensitive to modest changes in direction, shape, and stillness of the loading source. The above considerations indicate that complete and precise definitions of human tolerance levels will require large amounts of data on controlled statistic samples. Only in this way can the influence of age, size, sex, and weight be comprehensively assessed, and only in this way can mean loads and statistical measure of scatter be linked to specific tolerance levels. So remember, he was talking about statistical probabilities of head injuries also with vehicles. I'm telling you, this is all reversible error. They should have done a Daubert test on his methodology and look at this. Welcher, a biomechanical engineer, is not qualified to render expert opinion about the medical cause of plaintiff's injuries. Look at this. It is well settled that a biomechanical engineer is not qualified to render opinions about the cause of medical injuries. Look at that. A Massachusetts appellate court case in 93, while a biomechanical expert could testify the speed of the collision of a falling child with the floor, he is not qualified to evaluate the medical consequences of falls from various heights. Well, that's what he was doing, talking about the injuries to John O'Keefe's arm. Look here, proof of any causal connection between the accident and the disability must rest on expert medical testimony. A 2020 case. Look at here. Judge Cowan, order excluding expert testimony by defense biomechanical engineer. Welcher knows he's not qualified to give the proposed opinions in this case. In this report, he goes at lengths to argue that he is not giving opinions about the cause of Carol Cavey's injuries. And he goes on to say, I have not in any way, shape, or form made any type of diagnosis. Despite his shrewd phrasing, it's obvious Welcher's attempt to do just that. The entire purpose of Welcher's testimony suggests to the jury that the impact was not severe enough to cause the neck and shoulder injuries Cavey suffered, and which all of her treating medical providers has casually related to the motor vehicle collision of November 2nd, 2016. Welcher reviewed plaintiff's medical records and expert medical reports in this case. He readily offers medical causation opinions about the cadaver and human volunteer testing, citing his report. That's what we had here today. Cadaver and human volunteer testing. He was the human volunteer. Unbelievable. Okay, so he offers medical causation. He said no structural damage has occurred to cervical disc, cervical facts, shoulders of any of these studies. No brain injuries or concussions have occurred. That sounds like medical expert testimony. He gives opinions about the alleged effects of the force on Carol Cavey's anatomy and compares those forces to those purportedly experienced by test subjects in everyday activities. All this to indicate that Cavey could not have suffered injuries in a motor vehicle collision of November 2nd, 2016. He even goes further, though. Look at this, suggesting that the causal opinions properly reached by Cavey's medical providers are not reliable. If Welcher is not qualified to offer medical causation opinions, he's certainly not qualified to criticize the causation opinions properly offered by medical experts in this case. Despite this, Welcher cites the articles from the American Medical Association, including one titled Guides to the Evaluation of Disease and Injury Causation. That sounds like something a doctor would cite, not him. He doesn't have the qualifications to talk as a doctor, and offers vague conclusions about the reliability of causation opinions when they are based on the subjective history of the patient. Look at that. Welcher's opinions regarding the effect of the force to Carol's anatomy are unreliable. They do not consider a number of factors that would impact how a collision affected her, including the direction of the impact, her lack of preparedness for the impact, her size, her existing cervical condition at the time of the incident. They're based on delta V calculations that are not accurate or reliable. His methodologies have been rejected by courts across jurisdictions and by the relevant scientific community. Wow, this guy is so far out in left field. Look at this here. They also cite Steven v. Cooper. It's a Washington State Appellate Court opinion in 2012. It said the defense biomechanical expert also tried to argue he was not giving medical causation opinions. This is somebody other than Welcher, obviously. The Washington Court of Appeals noted the expert disavowed any intention of giving an opinion about whether the plaintiff was hurt in the accident. The court disagreed and excluded the proposed testimony, commenting that nevertheless, the clear message was that the plaintiff could not have been injured in the accident because the force of the impact was too small. Welcher's proposed testimony is a flagrant attempt to end run this court's clear prohibition of medical causation testimony by biomechanical engineers. It's not permissible and should be excluded. So, wow. Great motion here by these attorneys there at Jones Kelleher LLP in Boston. So let's see. That's Simons, the defendant. Christine Hawkins is the one. Thank you for passing that on to us so my wife could find it and give it to email it to me so I could present this. So awesome. This is astounding. that what we saw today in trial could not even happen in a civil court of law where nobody can go to prison for life if you're convicted. It's just money damages. And yet, this is what this guy did. He knows he wasn't allowed to do this. How could he not know that? Did he keep this from Brennan, a secret from Brennan, this opinion? This is unbelievable. So this is definitely mistrial material. We get with this rampant mistrial stuff day in, day out. This is probably as big a one as any. Norton, yeah, he's not entitled to give an opinion here. He's not qualified for it. The courts say he can't testify to causation. And that's just on a civil case. So now you're going to talk about something involving life and death for Karen? Yeah, he pronounces Celeste's name wrongfully on purpose. Sharon Joy, the judge left the last motion in the era. What decision can you make for the continuation on Wednesday? What effect can this have on Leslie's cross? This guy should not have been able to testify, in my opinion, based on what this case law is saying. He wouldn't even be able to testify to this in a civil case up there. And yet he's going to testify in criminal. I just. Let's see. If they start at 10 o'clock in the morning, wow, I just can't believe that. Cadaver stuff. The case law up there said exactly what is common sense, which is a cadaver falling is not the same as a live human being. You can't even bring it in civil. That is so amazing. I'm telling you, this is apparently the defense didn't know about this case because I think they would have objected to him including all this in his 140-page report. West Virginia, Karen cannot afford another legal defense. This court is intentionally taunting the defense knowing they have already lost because there was no collision. McRamble on Brandon complained about defense invading the province of jury in opening statements, but that isn't allowed. Yeah, I think I remember him saying that. Yeah, now he doesn't even bring up that word. Evelyn Santos, I think the jury knows this is fake. I want to see if I can post those things on X, that motion and that ruling on X. I mean, this was, I'm just thinking of this now. So this court opinion kicking out Welcher on a civil case, mind you, and this is a criminal case, and it's not some other state. This is actually in Massachusetts. So this is like really, really underhanded by the prosecution. And does Welcher know about this? This is sort of like an integrity issue, I would say, just like we had with Burgess. So you tell me Hank wouldn't ask about, has he ever testified in Massachusetts before? Has he ever been excluded as a witness before? Yeah, so who's the judge going to call tomorrow at 10? She needs some time to talk to her mentors. Yeah, the Commonwealth would have paid for the Lexus. That'd been part of their fee that they had to pay. Yeah, she'll rule in Brennan's favor, all right. But I'm telling you, if they show this case law there that we saw tonight, I just don't think they know about it. Brent Mack, you notice Celeste didn't object much, say he's going to bury this bozo tomorrow. Yeah, I just think, think about it. Hyde was also banned in Maryland, so learning curves, how could Brennan not know? Yeah, I guess ALJ, you're saying send directly to defense attorneys, let Brennan be surprised. Olivia Nile, it's amazing. Commonwealth can only find out-of-state experts, most of which have been excluded in other courts for these type of reasons, have major credibility problems. Yeah, can you imagine that? This guy's been tossed from testifying in a civil case in Massachusetts. Hey, that's John Steinbeck. Yeah, bombshell truly. John's been flying around. I don't even know where you're at right now, Johnny. Stephen Weisenhaupt, all these Commonwealth experts are hired guns, period. Nick Smith, how would they know about this? Would not come up with simple research. I mean, I didn't even know about this case law, but for Massachusetts, but I was just thinking in terms of like cadaver, objection, how is this relevant to a human? It's like also they talked about the percentages of head injuries from pedestrian strikes by vehicles. I don't know why they weren't objecting to that. So imagine that the most of what we covered tonight was the bodily injury aspects of John O'Keefe, it seems like, and how he's trying to pin Karen's vehicle as the one doing it. And if this was a civil case, he couldn't even talk about that in Massachusetts. Yet in a criminal case, he can when somebody's life is on the line. All right, let's see. Is there any? You guys have any questions? It's oh my gosh, are you serious? It's almost 1 a.m. here. All right, I'm going to shut it down here. So yeah, I don't know how much they provide expert for Massachusetts. There probably is some way to find out though among civil litigators. Yeah, and they're giving money to the Bar Association. Keep in mind one of the employees they have there. Oh, here I can look at that real quick. Aperture. I think was the guy's last name Klein. The guy that was former trooper there. He was in accident reconstruction. I think I'll recognize the face if I see it. Here it is, Klein. All right, hold on a second. Check out the Aperture connection to, let me get that comment out of the way there first. Sorry. It's not easy to remove comments on the on StreamYard. It's one of the gripes I have. All right, check out this guy. Retired from where else but the Massachusetts State Police. 2017, 29 years of service, was a lieutenant. So he's basically a guy like Trooper Paul that retired. Also like Trooper Paul's got an associate's degree. Got hired on here of May of 2024. So I don't know if that's why they decided to use Aperture. The reach back connection. Not for expert designation. If you look at the time frame here, he had his own reconstruction, but for a number of years, Klein and Associates. Look, he's testified in Massachusetts District and Superior Court, criminal and civil cases. Right here, look at this. Lieutenant assigned as section commander for the CARS, that's collision analysis and reconstruction section, statewide, consisting of 4 sergeants, 20 troopers. So that's 2009 to 2017. So guess what? Trooper Paul's been an accident reconstructionist for 8 years. So that means this guy would have been assigned over Trooper Paul and helped train him. So imagine that. And they're the ones sponsoring the Bar Association. So they have a some long-standing connections there with the prosecution. That's a good question. How can anyone be an expert with associates? Unbelievable, guys. Yes, can confirm this guy did train Trooper Paul. Can you guys believe that? They're beholden to the Massachusetts State Police and the DA's office because they sponsor the Bar Association. So they're in tight like this with Morrissey's office. Morrissey's office and also the state police. So there you go. Aperture's doesn't have clean, unbiased, neutral hands in this. Yeah. Yeah. I don't know how she found it, but she found it. So thanks. Thanks, Sonny. And also thanks for Christine, I think her name is. Olivia N. is trying to get my attention. Where is Olivia N? I don't. Thanks a lot, BB2, but please save your money and give it to the Reed defense. He has ties to them. Yeah, he retired from there. He knows all them guys. That's a connection. Oh, there's Olivia and Niall. I can't remember if I posted your comment up or why are you trying to get my attention? Okay, man, it's been almost 4 hours. So, all right. Sorry if I can't. All you have to do is Google Karen Reed Defense Fund. All right. So anyway, I can't believe we're almost on 3 hours, 40 minutes. So anyway, thanks for your support for Justice Cause. I just can't believe that today was even more bizarre than the Burgess testimony. Unreal. Unreal. So, all right. Hope to cover again tomorrow night. Thanks for all your support. And hope to be on tomorrow night as well for another exciting day. Hopefully this guy will get crossed and this thing will blow up for what it really is. It was an absolute sham. So thanks for all your great questions. Maybe I'll see you all tomorrow night. Take care. Be safe.